But you wad mine up and soak it really in gasoline before you can toss it at me.
Well, I would drink that first before I toss it at you. It sounds pretty good. Anything short of battery acid. Try.
If it's going that way, if it's going only that way, then there's still an opposite way. But I didn't put that.
When I was growing up, I played the violin, and I kept playing it for like 20 years. And a few years ago, I started learning to take lessons again. But then I found myself faking, like really bad, and like it's an improvement to the teacher.
So funny.
I have the same feelings right now, standing here, like, trying to please this.
But did everything come back?
Yeah, I did, but like it was, I didn't have time to practice. So like, I wanted to think that I was improving week to week, and everything was every elementary. So I'd be like doing a 4 game practice, and then the next week I was going to do phenomenal, but he believed that I was actually working on it. And so then after 2 months, I was like, this is really bad. I'm paying like $50 an hour to this man for me to believe that I was improving on this something that I already had to skill. I guess crazy, you know what I mean?
Sorry, I'm late. Your desk. Oh. We had a deal here.
What's that?
We had a deal here. Maybe one day. Okay. Anyway, everything being equal, morning. Good morning. Now. So how was this morning? Now, as I recall, last time we spoke, we were doing June 2013, weren't we, last week? Was that not so? We were going over the essays from that. And as I recall, I said that what we would do today would be works. Already been first. That's correct. Yes, that is correct. It's in my notes. It must be correct. Okay. And guess what? That's what we're going to do. And we have to time left over. Just like you did. Let's do this first. But this might make sense, particularly now that you've kind of seen what these essays look like. Again, for my purposes, I'm not trying to be facetious, but for my purposes, I'm just interested in your outline. Right? I'm not really super interested in your essays. I did look at them, and again, there's just always going to be. See, the reason why it's too early for me to look at your essays, among other reasons, but it's fun, really. Because what happens is as a practical matter, one of three things happen, none of which are really relevant to tell you the truth, or even you should take notice of. Number one is students that are returning, right, which we get many. I don't know if any of you are returning to law school or whatever else have you. Of course, already know this. So why would you compare yourself as first-year students to them? This is their second time through. You know, why is your first is their second? So that's pretty pointless. Number two is that some of you may work in a law office already. Okay, those students tend to be a little bit better than others because they have some knowledge of how motions work and things of that nature. Or three, you come from a long line of distinguished judges and lawyers, and you're, you know, whoever you're related to is helping you. So it's one of the three, none of which are relevant because you're all going to end up at the same place anyway, to be honest with you. Just some of you might take a little bit more time to do it because you don't know. They know that you don't know, things of that nature. I feel very strongly about that because, you know, the person who was actually the valedictorian in my class was actually at the end of it all, there was actually 24 students in it, 12 from the day class, 12 from the night, from the day one where there was 150. That's the school I went to. So here we were, 12 of us from about 80 or 90 students actually made it through. The person who was the valedictorian, we all knew her, obviously. She was, you know, the outstanding next, just kind of dates me, but she was going to be the next Ally McBeal. You remember that shit, that's how long this goes back to. And, you know, we always wondered how it was that she always came to class, she always had her briefs, she always had everything perfect, letter perfect. Whereas the rest of us were completely struggling, you know, and we were tearing our hair out. We're sitting there, she's never in the library, shows up right before, we don't know, right? Okay, it comes out later, you ready for this? She's married to a judge. She doesn't work. And what she does is, for whatever her reasons are, she doesn't study at our library, she studies at Pepperdine Library, for whatever her reasons are, which is a much bigger library, I'll grant that. I mean, we had one in each group, they had like 6, you know, so there's something to be said for that. So that was the valedictorian. And I got up every morning at 5:30, was at work at 6:30, managed to make it to class, I was at school by 3:30, so I could get into, you know, the library, you know. And when I actually, everything was said and done, you know, at the end of the day, at the end of my term, I was 22nd in my class. I was glad I had a number, quite frankly, because, you know, I can't compete with that, and neither could most of the other people. So when you actually saw the ranking, it was like, here she was, and then everybody else was way down here, and we're all bunched together. I mean, it just so happened I was 22nd, I don't know, you know, but I could have easily been 3rd. That's how close everybody else was, just as big back, you know. But think of all the advantages she had, right? And then of course, like the day after she got out of class, right now she's working in the Phelps. So, you know, that's the way life works sometimes. I don't know about you guys, it ain't never worked that way for me. My dad worked at the Department of Water and Power for 38 years. And unless I wanted to work there and be a meter reader, wasn't any help there. Sure as hell, there's a couple of lawyers in my family, but they lived back east. So it didn't really help me very much. So there you go. You lived out here, they lived there. So when I look at your papers today, you know, does this really tell me where you're at? Okay, it really doesn't. It can't. I mean, it might, but who cares? You see what I'm saying? I mean, it's just irrelevant. When I looked at them, I didn't see anything particularly weird, if that helps at all, although there are just some points of issue that I will mention to you because it's things you're going to have to do. But it's mostly just, you know, things of that nature. I mean, if you knew all the law, what the hell are you doing here? I don't understand. There's that road, right? Put it on, go apply to the Supreme Court. You already know everything there is to know. Do that, right? So, and we see lots, you know, again, I see lots of little things that, you know, again, will have to be corrected, but they're corrected. What's the big deal? So for me to actually sit there, you know, and I'm just being honest with you, but I mean, if I was to actually really read your papers and grade them and offer comments or whatever else have you, there'd be more red than black. So why should I do that, right? I mean, that's a confidence builder? Wouldn't be for me. I don't know about you guys. Yes,
So why are we doing them?
because you have to learn, and the only way to do it is to keep doing it. There's no other way.
But we're not getting it back with what's wrong with it?
These?
Okay.
No, you're nowhere.
So how are we supposed to learn from it if we're not getting feedback?
Oh, you'll get plenty of feedback.
Okay.
About that.
Okay.
Just not today.
Okay.
Oh, do not worry, you will get plenty of feedback. I'm the least of you worries on feedback at this school. Yeah, honest with you. But anyways, you know, again, it's a marathon. It's not a dash. For those of you that think it's a dash, it's not. Okay, you can be very surprised. And the other thing to remember is that when you're in this room with me, I have a very narrow mandate. Very narrow, and it's get you through the baby part. That is a very different mandate than teaching you the law, right? It just is, but somebody's got to do it. Because if you don't pass the baby bar, what's the point? I mean, I'm not saying there's no point to having a JD, that's fine. You know, I mean, whether you practice the law or not, that is kind of irrelevant to me. Okay? And it should be. There's no reason that would influence my decision about what you should or should not do, right? But on the other hand, if you don't pass the baby bar, I will tell you two things. One, you will not get your JD, so that's a problem. And number two, you will never practice law in California, which is most likely most of your goals. Therefore, this is just reality in the law school. It just is. I mean, we can ignore the baby bar all day long if you like. You don't like that, okay? Because, you know, it's not an intuitive test. I mean, are you starting to see that already? You really won't intuit how to pass it. You really need somebody to tell you how to pass it. That's short of that, you at least have to read about it or at least watch a video or something about it. Because you won't intuit it, okay? And you don't learn to do it in law school. At best, we teach you to write essays. The baby bar is not an essay-driven test. It may look like one because it doesn't look as much, but it's not, okay, because it's also multi-stage first of all. But on top of everything else, it's baby bar oriented. So you're writing for a very specific audience. Remember when I was sort of talking to you about that last week? I said you really have to know who your audience is, otherwise you just never be a lawyer. You'll be sending things to people that just won't make any sense to them. You'll be annoying, upsetting them. All points good and bad is different. And if you do it to the wrong person, like a judge, well, you know, they have very long memories, just so you know. Anyways, and there's one judge right now in, actually I did some practice for a little while in Ventura, California. I'm sure to this day she remembers me, and I was fairly sure she was going to have the bailiff shoot me. The woman was so nasty, she just didn't like me. And I could never figure it out until somebody told me what it was. And he looked at me and he says, "Oh, you don't know. It's true. Just so you know." You don't know? Because everyone in there knew. You ready? I look just like her ex. And she hated me.
Did you get a picture of him to compare?
I never did see him.
Oh,
No.
okay.
I was just like, yeah, I'm just going to leave the county. Is that how you roll out here? Anyway. So that's true story. Crazy woman. She ended up being transferred into family court, and I said, okay, that means the wives are going to win every case. Just wonder what she wants to do there. No doubt. Which to me doesn't bother me anyway, to be honest with you. But with that said, anyway, so that's what we're doing. Yeah. And so for me to actually grade your papers today in many ways is doing you a disservice. However, your day will come when I do want to see. But that's not it. but you need to keep writing. That's the only way to get better. And it has nothing, and that even has nothing to do with law school, believe it or not. If you're an English major, the only way to learn how to write is how. You need to write. You can't fear writing. You have to do it over and over and over again. The other advantage being of doing work over and over and over again is that in the baby bar, you are time. That's the other problem we have. So it's not just doing writing, it's doing it fast enough. You know, if I gave you all day to do an essay, you'd all get 100. If I gave you 8 hours to do an essay and I threw a book on your desk and said, here, use your book today, you'd all write really probably pretty good essays, I think. But you're not. You're going to get, 4 hours to do 4 essays. Okay, and you're not going to have a book and fill in the blanks, right? And so, the thing is where would you like to start? Let me ask you. Okay, would you like to start with the foundation? I'm happy to do that for you. Would you like to start on the first floor without a foundation? Or would you like me to grade your papers today? So let's just go right up the floor too, without the first floor or the foundation. Would you like that? No, you don't. Okay, you don't want that right now. It's pointless. Okay, you have to learn. Okay, you must learn. You must build. Everything leads from this to this to this. Okay, and that's not just as much like that. It's also your legal knowledge as well. It all builds on it. That's why you have these 3 classes. That's why we teach you these 3 in the first year, because they're sort of the building blocks of other types of law. They really aren't. I mean, these are the ones you need. Theoretically, we don't need the other ones. I need to have a society which is 3 types of law and just give everyone a knife and see who wins. Okay, so with that said, let's go ahead and let's go back to where we were last time. And then what you take away from today will actually help you see what your problems were today, because now you kind of have a better vision of what the actual task is. Yes. Okay. All right, let's do that. Far more valuable, I think. So, question number 2. Do y'all still have this? I did ask you to bring it.
I did. I apologize.
Who needs one?
I do need one.
Oh, I need one. Oh, yeah.
No, I'll just look them up.
No problem. There may be someone that can help. Right around the table somewhere.
Let me see.
Or,
I'll just make a couple copies. I'll be right back.
thank you.
2 seconds.
Okay.
What's that? No.
I had question 4. Which was the other? No, that's one we just does that one. Oh yeah, you're right. That's one so confused. I got it. They're all titled the same.
You call this doing it.
No, this is 11:30.
Question 3, Billy.
They're all question 2, question 4, question 3.
Yeah.
This one says Billy and Cindy.
Yeah.
What time do we get up?
3.
3.
We do. I thought we had lunch.
I know.
I'm so hungry right now.
It says right now 11:30.
Give me some hot sauce. Drake's next in trouble.
Well, we have,
I see you. Yeah.
he's gonna make us go to lunch at 11:30 because he wants everyone to be eating at the same time so we could
But
make
they all get out, right?
what?
Don't they get out?
I don't think.
4 more minutes.
Yeah.
Why do you start?
I don't get, so next week is when we're here from 8 to 5.
What?
Yeah.
Is that mandatory?
Why?
I know.
Suggested.
Okay, because, I don't think my family is going to be happy about that.
Because it's the MCLE and we should, but I don't understand why.
What's the MCLA?
It's
Oh, no, I don't think we have to stay for that.
Does anybody else need a copy?
Optional. Do you
Does
guys need
anybody
one?
need a copy?
I think I have it, but I'll.
do torts. Okay, last time we did what did we do last time? Criminal law, right? Okay, so today we'll do torts. Okay, so now, much more important that we learn a methodology, how to make it through all of these, and then we'll attach it to this essay as we do it. And then we'll go ahead and, if we have time, we'll look at today's essay. But you should start to see the comparisons for yourself. I mean, it won't, that's not much of a stretch. Okay. And again, you don't really know a whole lot today, too. That's the other thing. So, you know, don't hold it against yourselves. I honestly would not. Okay, away we go. All right. So this is essentially how torts work, right? We have intentional torts. We have negligence. Okay, so you got to figure out which one you're in. First off, have you guys done any negligence yet? Okay, so you're still paying attention. Okay, and then because of the nature of the beast, you know, with torts, see, I can't really draw 4 boxes for you. They don't work that way. Because I'll give you a big hint for your tort class. Torts are very driven by the plaintiffs and the defendants. They're plaintiff and defendant specific. Whereas in criminal law, there's just defendants and everybody else, right? And then in contract law, there's plaintiff, you know, contract A, contract B guy. But in torts, it's a much wider world. Certain torts only fit for certain persons. Okay, so what you have to do in a tort question is always understand who's the plaintiff, like to a very much greater degree than you're probably doing now, because it all plays into it. And you also have to understand who the defendants are, because there's lots of defenses, offenses, and points in between that are just based on who you are. And it also drives your analysis as to whether you can actually bring that suit or not. Now, obviously, everyone can bring an intentional tort suit, but did you know that children under the age of 4 generally are thought to not be able to intend? So again, you see they're already making decisions. 14 is another kind of, 14 in common law was basically when you were thought to be, you know, hangable, for lack of a better term. And so those kind of things. So when you do torts, always make sure you understand very clearly who the plaintiff is and who the defendant is. It drives the analysis, drives what you can and cannot bring. You see that, right? We'll talk about that. That's how you'll always know what to do, okay? Because you'll see that only these persons can bring these torts. Got it? Okay. What you're going to want to also study later is defamation, which is a separate tort. You're also going to want to study nuisance, which is a separate tort, and you're going to want to study products liability. That'll be what we'll do for today. There's a couple of other minor ones, but those are the big major ones that you deal with over and over and over on the baby bar. Okay, intentional torts, negligence, defamation, nuisance, and product liability. Those are the ones you see over and over and over, okay? And there's subsets to that, so I'll show you a little bit of that today, okay? All right. But the reason why you learn intentional torts and negligence first is because they generally apply to everybody, whereas defamation, nuisance, and products liability do not. Okay, there's only certain plaintiffs that can bring those charges, and there's only certain defendants that can actually be, let's just call it, be forced to defend. Okay, that's the way it works. All right. So very important we know these things. When it comes to intentional torts, not very complex, to be honest with you. This is something that's not terribly hard. In fact, for all intents and purposes, you're going to learn assault, battery, false imprisonment, and IID. That's all you really learn. And then defenses. Don't forget your defenses. Now these are against persons. Okay. What's the difference between criminal assault and battery and tortious assault and battery? Anyone know? Anyone tell you yet? Yes?
Just the intentional addiction at the beginning.
yeah, one's criminal malice driven and one's not. One's more like an accident, you know, even though you're kind of doing it intentionally anyways, but you're not really doing it with the intent to maim, kill, bodily harm. You might end up doing that because you're stupid. Sorry, something like that. Okay. Anyway, you also have against property though too, which I don't know if you've seen yet. Is you also have intentional torts against property. Okay. And what you have there is you have trespass to chattel. You have conversion. Right? Okay, you see those two? Yeah, okay. And then the other one you're going to want to put on your list is trespass to land. Because believe it or not, that is one. Okay, you'll see that later. Or if you've not seen it already, right? Okay. So those are the ones you have to know. So in other words, when I do torts, what I do is, you know, it is a little easier, just have 4 boxes. But honestly, you know, not that I would do this on the baby bar, you won't have to. But for now, go ahead and just draw your box. And defenses, maybe consent, maybe necessity. You'll see those later. Those are kind of commonly tested. And when you're done, count the checks, put it in order, and you're done. That's how you can do torts for the baby bar. Easiest way.
Put them in order, like, what do you mean?
Swallow this shut.
Oh, that's the
These are
exact
the
order?
easiest to the hardest. Yeah, believe it or not. So, I mean, if you have no other way of doing it, do that, and the reader will go, oh, must have talked to that drunkard guy. And that's what they'll say. That's fine. That's the way it works. Or just do it across if you like, you know. Anyways, but we'll do that later. That comes down the road. With negligence, just so we'll do a little bit today, basically, you have 2 torts that you're going to deal with on the baby bar. The first one is actual negligence. Okay. And then, as you will see, I'm just giving you the basic. Okay. What you're going to want to do is you're going to want to deal with it in 4 parts because that's what you do. Duty, breach, causation, and damages. And then what?
Defense.
Always defenses, right? Okay, and that's how you'll basically look at negligence. The other negligent tort that you usually throw on the end just in case, because it's usually pretty okay, is NIED. How about that? Huh? There you go. One's intentional, one's actually negligent. And there's 2 different ones. So that's really what you're looking at. Okay, and we'll hit the other ones when we have a chance, but you see that they're all very driven by their facts, by their elements. And so what you do is you just learn the elements, you lay them out in the road, you plug in the stuff, and you go. That's all you do on the baby bar. Learn the elements, you put them in the right order, you take the facts, you plug them in, and you go. If it makes you feel better, I'll teach you the entire list, which I will do. You can go through the whole thing as you practice. If you say there are no facts for this, then put that in. Better to learn it that way than not. Okay? And it doesn't take that long anyways, and quite frankly, if you do it on the bar, they don't care. Because then they say, oh, you were talking to that drunkard guy again. That's what they do. I'm not the only one who teaches this, by the way. Just the best. Anyways, with that said, okay, so let's go ahead and take a peek and at least get through this today. Yeah? All right. So again, be very aware of your plaintiffs and your defendants. Okay, and I'll show you, I'll make a big deal out of that today as well. We go down to the call. Okay, always follow the call. Okay, now we're looking for structure, but again, very simple structure. If they give you structure, you use their structure. If they give you numbers, you use their numbers. If they give you letters, you use their letters. Okay? Just whatever they give you, throw it back to them as much as you possibly can. All right? If nothing else, it makes it much easier on the reader. You're always going to know where you're supposed to be. Okay? All right. And let's see. If we see question 2, again, keeping in mind we do not know what it is. It could be any one of 3 subjects. Okay, we have to figure it out. The best way to figure that out is to start with your call. It also helps you figure out what question you're being asked before you try to answer. Common sense dictates. Therefore, we start with the call still. 1, is Bill likely to prevail? So kind of likely to prevail. What does that tell you? What is it asking you? Is that a high standard, a low standard, middle standard?
No.
Kind of low. It's kind of, I can think of lower, but it's kind of like somewhere between middle and low. It's a little bit higher than something else. Light. Okay, so again, are they saying you're absolutely positively liable and you're gonna have to pay? No, of course not, because there's no way to actually know that. It's almost impossible from these facts. So again, they're not asking you for a whole lot. Therefore, what does that mean to you though? What, as a practical matter, after last week's lesson, should you be thinking when we know that it's a low standard? What does that tell you? Yes?
Your analysis is going to have to reflect the likelihood of their ability to prevail.
Fair enough.
Have that mentioned, maybe explicitly, or just dictate it.
Well, I mean, I would probably put in my conclusion, therefore it is likely that. That's a good move, because that means you read the question. Very impressive to a reader. You'd be surprised who doesn't. They get all sorts of crazy stuff. What else does that tell you too when you get these low standards? A couple other things, and one comes to mind right away. What's the rule? When you have a low standard like this, which you will get on when in doubt, put it down. Might be, I don't know. You don't have to make a decision. There's a fact here I can use. When in doubt, put it down. Okay, so again, don't skip over it. Learn to write the most, not the least. Okay, learning to do shortcuts is the quickest way to get a shortcut to what? Out the door. Don't do that. Okay? Really, learn to do the long form. Okay? The longest form, not the shortest. So that's what else it tells you. Anything else that sort of can benefit us from knowing about these low standards that they're actually, because other people are sitting there saying, oh, well, wow, what's he going to have to pay for? And the answer is, I don't know. You're not asking me that. I don't have to tell you that. Anything else? Okay, let's move on then. That's good for today. On any intentional tort claim. Okay, intentional tort. If they ask you for intentional torts, what do? Do intentional torts. Okay, you don't have to do negligence. But if it makes you feel better and you want to put in a negligence part, what should you do? Let's just say you did. You probably wouldn't on something this simple. But let's say you were deciding on what would you do? Well, you didn't really ask me for negligence. It would be due to breach causation, but there isn't anything here. Bye. Move on, because it'll make you feel better. You hit everything. See, now you're just doing a list. They know that. They don't care. Matter of fact, they like that. If they see you're just doing a list, they're likely to look at your front page and go, that looks pretty good. They're likely to flip to the last page and say, in conclusion, it is likely. Great. Flip the middle. Oh, yeah, that's a fact there. That's this here. Wow. No really big mistakes. And 7. Don't even reward.
That really happens. You got very end and say the last week stuff.
I never do them. And I'm always within 5 points. Never off. And I'm usually right. Yes, the average baby bar paper that passes is read in 30 to 60 seconds. The ones that don't pass are the ones that go on. Just, and no, I'm not kidding. And there's many, many people who will tell you. Just, hey man, I get paid the same. What does that tell you? If it takes me 30 seconds to grade your paper, I get paid $3. If it takes me 3 minutes, I get paid $3. If I get paid 3 hours, I get paid $3. They pay by the essay, not by the hour. So that's got to tell you something. Right? I'm not going to spend all that time. And if I do spend, 3 hours on your paper, who's going to pay for it? You. Right? And remember also, again, not to be overly cynical, but it's in the reader's best interest to give you a 70, because then you can't challenge it. You passed. What are you going to challenge it on? There's no damage. If he gives you he or she gives you a 65, it's challengeable, not a pass. So again, there is this sort of at least sort of common theory of rational thought that it is actually in better interest to give you a 70. On the other hand, they can't give you all 70s because then the bar turns them back. Okay. So they know that one too. So, okay. So again, what you want to be worried about is you want to be in that position where you're worried about 65 or 70. That's where you want to be. Okay, because again, it's a subjective test, who knows. But if you get that high, then everyone else who's doing 50, 55, 60, they go into the 80% that doesn't pass. At least you're in the ballgame, right? So that's what you want to be. But again, it's that sort of swing group. It's sort of the papers that aren't better. It's the papers that look better that tend to pass. Sounds funny, but it's true. Just telling you. How many of you, don't raise your hand, but how many of you hand wrote today? If you can avoid handwriting, I know that there's theories in this school about otherwise, but if you can find it in your, within your grasp to type, I would type, because readers don't like handwritten papers. They don't. So if you can, type. Okay. But if you can't, right, if you have to make that decision between finishing and then typing, then make sure you finish, because not finishing is worse. That's not good. But again, if it's just like, oh, I could do either one, but then choose typing, because readers like it. I can tell you right away that whenever I get papers that are typed and papers that are handwritten, I always put them in two piles. I read these first, I read those second. Why? I don't want to read them. Honestly, really, I don't want to read them. But I read them. If I can read them. You see some of these papers you get. Wow. Anyways, so we'll talk about that as well. You'll have to make that decision for yourself. You can, and right, they still allow you to do so. So something to think about. Okay, so Bill likely to prevail on any intentional tort claim against A. Okay, Bill, A, here's the famous discuss, which they don't use too much anymore, but still see it kind of like that. All right, so we're going to be looking for Bill, we're looking for A. Intentional tort claim, it's a tort. Okay, that's good, and it's intentional torts. All right, so we're thinking about this, right? Good job. What else is there to think about? Nothing. Just think about those. They're the ones that appear on the bar 90% of the time. So think about those. Learn those first. Is Cindy? Oh no, there's a third person. Is Cindy likely to prevail on a negligence claim? Let's see what they're doing to you now. They're going to bounce you among different ones. Okay, so now they're crossing over. They don't always cross over. Sometimes it just says intentional torts. Sometimes it just says negligence. Sometimes they limit you, so you kind of have to pay attention because it's what they're asking you to do, right? Again, say discuss, okay? And 3 is Debbie, D. That's A, B, C, D. How many people do I need in this question? So I'm already upset. But we'll deal with it. To prevail on a negligent infliction of emotional distress claim. So again, see, there it is. They like to test on that. All right, have you gotten there yet? Not so, right? Okay, that's fine. Okay, so that's what we're looking at. But notice that that's it. I mean, there's a couple other words you'll learn, that you might want to throw in some disrupts or something. We'll see, but right now I wouldn't expect you to know about them at all. You even done any of those yet? Intentional misrepresentations? No. I don't think so. It's still too early. But these are the ones you really have to know because these are the ones that appear in 90% of the bar. So make sure you got these before you get everything else. Okay, structure-wise, we have 1, 2, 3. We really have had no other direction, so what are we going to do? That's just our structure. So we feel good about having our structure. We're going to do issue and defense, issue and defense, issue and defense. There it is. There's our structure. It's going to be 1 to 2 to 10, 3 to 10 for all the different issues. We're done. Just do that. Don't think. Do. right? Sooner or later, you'll get more sophisticated and you'll say, I'm tired of putting defenses on everything. Right? I don't care. But for right now, think about it. Think, discard. Think, put down. Think, discard. Think, put down. Okay? When in doubt, what do?
Put it down.
Put it down. Okay? You don't lose points for putting down things that aren't on the bar. All you lose is time. Okay, so just make sure that if you're putting it down, there is a fact that makes you think that. You're probably okay. And what's the other rule? Never use if, because if you start saying if, you're going to make up facts. If you make up facts, you'll fail. They'll catch that. Lawyers don't make up facts. We all love to make up facts. You know, my client's perfect, never did anything, got all the elements, just give me my money. Why are we even having the trial? Speaks for itself. But if I can use if, I can do that. Well, if he had enough damage. And what do we never say in court?
I think.
Hmm?
I think.
I think. Never say that, because the judge is probably going to throw a gavel at you. So don't do that. Okay? You don't care what you think. We know what you think. We know. You want your client to win. Got it. Right? Don't do that. And it really will upset someone. Okay, move into the top now. Abe, oh, there he is. Good. Wanted to cut down a tree. Ooh, let's think about that for a second, because this is torts. Okay, so we want to think about cutting. We want to think about Abe. We still don't know anything about him, right? Which is not good. We want to know as much about them as we can, but we'll see that later. He wants to cut down a tree. So what do you think about that? Cut down a tree. It's a hard question. Okay, so what do you think about cutting down trees?
Land.
Okay, what else? Okay. What else? Chapel.
Cutting, there's like an instrument.
Yeah, maybe arm, maybe, lots of torts. Tree falling on somebody, who knows? But again, we want to be able to extrapolate and then yes, no, right? So again, we want to use everything we learn. We want to use everything we read. It just makes sense, okay? Again, just learn to consider the possibilities, but, but as you go forward, you'll be more sophisticated and you'll start discarding, okay? All right. That was growing on public property. Well, what do you think about that? Public property, what comes to mind? Not private, first of all, which is pretty important in our society. What else? Maybe still your trespass to land. Does that go out the door? Public property, can you really trespass on public property?
Yeah.
Damage is good still. You can still cause damage on it, which you will have to pay for.
Yeah.
But on public land, can you really trespass? The answer is not really. You can't do it on public land. But who knows? They're tricky. Let's see what they do. Again, we discard, right? Keep your mind moving. Don't shut yourself off with the question, right? Use what you've got, right? Don't worry about it. You'll get much better at this. It seems confusing at first. Don't worry. It actually, when you learn to do it, it's actually much easier than the opposite, and you'll start hitting more issues that way. And you'll always hit more issues if you consider the possibilities. If you shut yourself off. Right? All right. Bordering his house. No. So his house, that's private property. Tricky little bar, aren't they? Because he did not want to rake its leaves. Okay, so let's just stop for a second. So here we have a guy's house, and there's a tree hanging over his property. Obviously, he doesn't want to rake the leaves that's falling on his property, but it's hooked to private property. Now, here's an interesting question for you, believe it or not. If you have a tree in your house, on your property, and it's hanging over your neighbor's house, over the fence, and let's say it's a fruit-bearing tree, who owns the fruit? Is it yours because it's hanging over your house? Or is it still the neighbor's because it's attached to their tree? Interesting question, huh?
I think it's your fruit.
Okay, you think it's the,
I think it's the owner of the tree's fruit.
okay, the owner of the tree. Okay, anyone else want to take a guess?
What, I mean,
more fruit then, because anything over your fence line is yours?
Possible. Okay, what else? Anyone else want to take a guess? I mean, it's one of the two. Yes.
I would say it still belongs to the owner, but it does constitute a trespass. So tree is trespassing, but it's still the owner's
What
property.
did you say?
Yes. Trespass alone.
That's correct.
Yes.
It actually is considered still part of the land because it's attached, as are all shrubbery and things of that nature. But it is trespassing on your land, therefore, if there's any damage because of it, you have to pay. But technically, you can't pull the fruit off of it. Weird, paying for it. But that's never happens in society. But technically, that's true because it's still attached to the land.
I thought you could cut anything that's in your yard.
I got in trouble for this.
Theoretically, you can, but you really shouldn't.
Yeah, you cut something.
If it's not attached to the property, would you cut it
That was
off?
hanging in my property. I got
Well, I know
That'd be
it's
fine, right?
it's different.
I come to bail them out, they only have like 20 minutes left.
Oh, okay. If I knew how things work here, I could have sworn she said I had an hour. We haven't been talking 40 minutes, have we?
No.
Is that true?
Probably not.
No, it
It'll either be me after lunch or we'll pick up where we left off.
You know, yes, I had this incident happen.
My neighbor's pine tree was in my yard making a bunch of mess. I chopped it off. I asked him first, I was like, "Are you gonna cut it?"
Well, you know what my answer to my was? I always say, yeah, what are you gonna do?
It's not gonna be a city tree.
Yeah, I said, or as I like to say, what tree? There's no evidence. There's no tree here. What are you talking about? I'm gonna stick my dog.
I need to get it together. I need to get it together.
Don't forget to sign in.
Yes, sir.
How are you? Good?
Good.
Good.
Go, yeah.
202.668.
you guys here today.
All right.
I was just told, pick up where you left off. Plenty to do.
Yeah, oh yeah. Giving us that snapshot of
Strangely, that's what I wanted to do today, so I'm actually not. In case anybody comes in here, he says, strangely, that's what you wanted.
no, that's great. We're not even on negligence or anything
Yeah,
else,
so
so
not even there yet.
but
So-
getting that picture is really helpful.
Yeah, I wanted that, and I wanted just to focus your attention on plaintiffs and defendants. You know, and we'll do more.
I thought it was good.
I'm not going.
Oh, okay.
I'm actually coming back to hear the speaker.
Right.
But I will not be instructing the
Yes, until.
Oh, you're gonna be right in the center of the room and then the others are around here. So they're always spread around. Pretty much. The one else always on my sit before there in the room. Oh, I would be.
Some of us don't even fit, like,
Oh, stop. And, well, that's because the camera angle there and so the students are, oh yeah, so you need me in the middle. Yeah, I will start it. What division are you in, Molly?
News office, Central Salt Chocolates.
That was Sammy. That was Sammy.
Do we have a couple of they're not even. Doing something like, I'm thinking like, facial expression. I'm trying to see here.
I know.
Legal memos.
I want to say it.
Yeah, no, we have to watch out.
I'll log on with my son Mike. Just if you can.
So now I got all your treatments. So you look like you're focused after here. See really well.
No, I'm actually.
Like, if you know the day,
And then I'm sort of looking at like, so that I'm like reading something else. That's why like scissors are that big. Oh my god, this one like, I hear my name. So I'm like reading something
Everybody
else.
walking over here, like, we're doing essays. You're like, wow, he's funny.
You're like, so no, we're not the same age. Or like, we can change that to yes.
Yeah, but like you just turned it
They do the gum stuff. I wish I had done the graph. I need a lot. Well, but they did not for no, it's the possibility of protection.
Yes.
No,
Some people are like, I don't want the pain.
I just need to mark.
I'm very, I think because I wrote, I kind of wrote like my the other two,
Yeah. I think.
Nice to meet you, sir.
I mean, I know it's awful.
Yeah, and she'll say, I did it, okay.
That's just the idea. That's what yeah, to review.
No, I just have a question, but I checked
But the other did. But I felt like it was like inconsistent contrast. And so here's one complicated. And I'm like reading, and I'm like, so like the contractors and the subcontractors.
So I'll read during the weekend. I'll read. During work.
Yeah, I missed
Time.
Everybody take their seats. Wait for you. Yes, I got all day. I know what I want to do. I want to talk. Works every time. All right. Okay, so today we have a guest speaker. It is Molly Tucker. She's from the Riverside County DA's office. She's been with them for 7 years. I think you will find her topic interesting, something we don't hear a lot about. She deals with sexual assault child cases. Pretty good, huh? And on that note,
Thank you. Sexy, right? Oh, I know. Funny. What's our mix? 1 Ls, 2 Ls, everyone across the board?
All of them except 4 Ls.
Yeah, okay. I'd like to do this interactive as much as possible. Please just jump in at any point in time. What I was told was basically talk about how I got to where I got, and maybe you guys can see lots of different paths that hopefully other speakers have talked about, and realize that there's no one way we become an attorney, or there's no one path. And hopefully I'm one of those examples for you guys. So like your professor said, I handle sexual assault child abuse cases. I've been with Riverside County DA's office here, 2 blocks away or whatever, for 7 years now. And I've been an attorney for 8 or so. I look really young. I realize that. I came from LA before that, and I worked for LA County DA's office. I clerked for them through law school. And I'm going to talk a little bit about that, but I'm going to go backwards. I knew from a young age that I wanted to be an attorney because it sounded cool, and that was pretty much it. They make lots of money, so I want to do that, but I had no idea what it meant or anything. And so through high school, through the track of, school's pretty much easy, so I'll just continue on and keep going, graduate regular college, decide, LSAT, no big deal, I'll take that. I decide that I don't want to be in debt for the rest of my life, so I decide to go to a kind of a bottom tier law school that offered me basically a full ride, because I didn't want to be paying for the next 20, 30 years like all of my friends are. I did just that and went to kind of a lower tier law school, which was great. Had no idea what I wanted to do. Just thought, I'll just make money and do what everyone else does and do civil or something, and realized one day in Civ Pro, and I was like, I hate this. I hate everything about Civ Pro. I hate everything. And it doesn't make any sense to me. I still cannot explain to you what summary judgment is or anything related to civil procedure. And thankfully I passed the bar miraculously. But I realized I didn't want to do that. I realized, torts, this is really boring, and just people sue each other and I couldn't care less about money. I mean, I'd like to make money, but I want to do something that I'm passionate about. So, also wanted to kind of go backwards. Meanwhile, I'm trying to figure out what I want to do, but I know I want to be an attorney, so I'm working towards that. And then personal side, I knew I wanted to help people. I was an only child, product of a very abusive family. I grew up in San Pedro in Los Angeles, which is the port city, really, really poor area. My mom and dad would actually pick up like cans and recycling stuff, and people had no idea because I don't look poor. And that was my life. And so I knew I wanted to get out of a situation that I was in. And it was also a very abusive household. My mom was an alcoholic, my dad was physically abusive, and it was bad. So I wanted to get out. And I figured, hey, if I become an attorney and I work really hard, I can make money and get out of this bad situation. So that was kind of what directed me. But I didn't really understand what that meant. So work, because I figured I can work out of a bad situation. The second I turned 18, I basically am not emancipated, but I start paying my own way for everything. I've been on my own since I was 18. When I went through college, scholarships, continuing on, and that's why I also went to a lower tier school, was so I could continue that. I knew that I wanted to help people. I wanted to specifically help kids. That's why I do what I do now. I wish someone would have realized or stood up for me in a really bad situation that I was in my entire childhood. And I wish someone would have realized and stood up and been my voice. That didn't happen for me. So maybe I'm trying to make up for it now. I don't know. Either way, I knew I wanted to help people, and I knew that I wanted to have a much better life than I ever had growing up, or that my parents could give me. So law school, it was in Fullerton, and I think it's moved now, the law school, but I actually moved in with some other obscure family members, commuted, and realized I don't want to do Civ Pro, or civil procedure, civil law type things. Constitutional law is really interesting, but who makes money at that, right? Like, what do you have to be a professor or something? And after the first year, there was a program that was offered, like a study abroad type program, and it wasn't offered through my school, it was offered through like a New York law school, but you have access to study abroad through other schools during summertime. And it was a human rights type course, and it was 4 weeks, and you did 4 countries, which I was like, that sounds awesome no matter what, right? and it was international law, human rights. So I decided to go thinking, this is it. This is what I want to do, right? This is, how amazing is this? And we literally went to Geneva, we went to the Red Cross, we went to the United Nations, and I learned so much amazing things about how everything functions and Geneva Convention and the laws, and to be actually sitting in these buildings where these things happened, you know, just incredible. And I am bored out of my mind, realizing this is just so big picture, and it's just government, and no one's helping an individual person. And that's how it felt to me. It just felt sterile. And I was sitting in this gorgeous room, surrounded by other, I think it was probably maybe this many people that went on this trip. I mean, trip of a lifetime. Every week was in a different country, you know, Paris, Brussels, London, and then Geneva. And to be sitting in that room, and there's money everywhere, right? Literally the clock on the top was a Rolex clock that's like this big. And I'm just sitting around here and I'm like, well, this is all the things, this checks all the boxes, right? And there's no passion, there's no inspiration, there's nothing that interested me about it, about what they're saying. I mean, yes, it's all good things, but it's so big picture, and if I'm doing that, I'm never dealing with people. And it just felt empty to me. So I come home from what was a very cool trip and realize, okay, don't want to do that, don't want to do international law. What in the world do I want to do? I have no idea. So I continue on, and I have an uncle that owns a alcohol diversion program, like a, you know, you get a DUI and you go to AB 541 or SB 38 or whatever those are. He runs one of those programs. And he's like, you know, have you ever thought maybe criminal law? You know, I deal with courts a lot. You can actually deal with people then, right? And I'm like, well, I haven't really thought about that. That seems, I don't know, those people, I see them on a TV and it sounds terrible, right? Yeah, all right. Well, he's got a friend in the DA's office in LA. And they were like, hey, we'll just meet with you and you can clerk. So I ended up clerking second year. It was a 3-year law school. So second year, basically 2 days a week. And I'd go and I'd do some prelims and just a little bit of stuff. And they just let me read some cases. And I realized immediately, this is the thing I've been missing. This is the thing. It's like when you touch it, probably like, I don't know, maybe you guys have had that one class where you read that one case and it grabs you and it's so interesting and you can't stop reading it. And most of the time, you couldn't care less about what you're reading, but it's that one topic, it's that one, I don't know, intellectual property, it's contracts, it's whatever it is that starts to grab you. And it was in that moment when I was finally sitting with my first criminal law case, and it was so boring, and it was like possession of drugs, like who cares, right? But at the same time, I knew in that moment, this is it. I'm looking at these DAs that are meeting with their victims, and they're sitting down, and there's literally this personal connection, and they're able to actually talk to them, interact with them, hold their hands, help them. And I was like, this is it. This is what I couldn't get with the international human rights, all of that. This is that personal connection. And then there's the feel-good part of making sure that this person, whoever it is, isn't committing the acts anymore. Not drugs, but a violent crime, right? So, second year of law school, I clerk just like 2 days a week. Summer, I work the entire summer just volunteering because all of a sudden this is what I want to do. And I figure, hey, I want to work for LA. Makes sense. You build up your connections, right? That's the whole point. And third year, I ended up taking night classes in law school so that I could continue to work 5 days a week for free at the DA's office. I had over 100 preliminary hearings in that time. I did 3 jury trials, which was good at the time to be able to do that much, and tons of experience and invaluable just interactions with people, right? Getting to know so many different people and them knowing you. That's everything. We all know that. It doesn't really matter, especially criminal. It doesn't matter what law school you go to, which thankfully I found out. All that matters is your connections and what you've done, your experience. So I realized, okay, this is great. This is absolutely what I want to do. I don't know particularly what I want to do with the DA's office, but I know this is, at least I found it, right? Like at least I found the job. Then it was 2011, graduate law school, and there is a massive hiring freeze everywhere across the state. And they're not hiring anyone in any government office whatsoever. Okay. I continue to volunteer, do a post-bar clerk type situation for LA for a little bit, and realized that I don't know if I want to live in LA. I don't know if I want this life. I know what job I want, but I don't necessarily know if this is where I want to do it. In LA, for LA County anyway, you have to, if you work in, let's say you work in South Bay, which is where I was, the courthouse I was in, which is in Torrance. Well, that's great, except 6 months to 3 years of your entire career, you are going to be moved from office to office to office. You'd be sent to Compton, Inglewood, Montebello, downtown, and that would be for years at a time. And I realized that sucks, and I'm not interested in that. I would love to be able to be close to where I want to work, right? I had a friend who worked out here in this DA's office, and I didn't even know. I didn't know India even had a courthouse. I know, yeah, that's an idiot. My family would vacation out here or make friends out here, and so I would come out here as a kid. And I loved the area. I absolutely am crazy, and everyone thinks I'm making it up, but I'm not. I love the heat, I love the area, I like the people, I like kind of the sleepy town feel, and I don't know if it's just because I'm from the big city, right? So it's just, this is what I love. And so I was like, wow, I could move to where I want to live, and then you work in the Indio courthouse forever. So I live 15 minutes from where I work basically my entire career, which never would have happened in LA. So I realized that's what I want to do. I know what I want to do, and now I know where I want to do it. Except there's this massive hiring freeze, and I have no idea how I'm going to get hired. I graduated law school and passed the bar, took 2 tries. Doesn't make any difference as long as you get your bar card. That's all they care about. They don't ask you how many times it took. That's a whole different story. But the moment I actually passed the bar, I knew what I wanted to do and where I wanted to do it. And so I decided that, well, basically gotta do what I did in LA. I had all these connections in LA. Well, sucks. Gotta start over, right? It is what it is. I worked 6 months, 3 jobs in LA to save up enough money to basically move here. Didn't have a job. Didn't know anyone except for the one DA that I knew who was a misdemeanor attorney, so I knew he wasn't going to have much clout in Indio. And so I moved to Silverhawk apartment in La Quinta because it was a nice little area and I didn't know anything. And I was like, oh, cool. Literally never lived here. I vacationed here sometimes and that was it. But I knew I love the city. I like everything I've heard so far and I know where I want to work. So that's my big push to you guys. I'll tell more along the way. But a lot of times I have friends that they know what they want to do, and so they just apply for any DA job or whatever type of job on any board for the state of California, right? It's like, oh, Fresno. Yeah, I live in Fresno. Sure. And then they go and they're terribly unhappy because it's quality of life. So what I did is I realized, no, I want my quality of life to be good, and I'm willing to work for it and maybe scrape and save to make sure that the rest of my life is hopefully better. So my big thing is move where you want to live and then find the job you want. Because you're not working your entire day, you're not working your entire life. And then, right, it makes sense to be, in my mind it does. So that's what I did. I worked 3 jobs, saved up for 6 months, and then moved here, and I moved in, had like 2 boxes worth of stuff and walked up to the DA's office and I said, can I work for free? And they said, okay, are you kidding me? Who does this? And after 8 months, I worked for free for them. I had a full caseload. I was one of their misdemeanor attorneys. There's so many problems with that, but I was more than happy because I was getting the connections I needed. I was getting the experience that I wanted, and I was loving what I was doing because I was interacting with victims. I was interacting with individuals where I knew I was affecting their life. Although it was little misdemeanor cases and maybe it's just basic stuff, but I knew that this is what I want to be doing and eventually I'll get there. At this point, I have started to figure out what type of law I wanted to. While I was clerking in LA, I helped out in the domestic violence unit. And during that time, I actually got the opportunity to second chair a felony case. Second chair, you know, so like you got your main attorney, right? And then you've got a junior attorney that sits there and kind of does some of the grunt work, and maybe if they're lucky, they can question a witness, right? So that's what I did on a fairly serious kidnapping domestic violence case, where he actually took her across. This was his longtime girlfriend. I think it was a gang type situation, and actually took her, put her in his car, took her across the state lines from basically Vegas, Nevada, over to California, and he just beat the living crap out of her the entire time. And a lot of it, you actually hear her, she's in the trunk of the vehicle, just gnarly, right? Just bad stuff. And I was ecstatic to be able to be involved with a case like that, to be able to at least sit in on these victim interviews and be able to at least help or maybe give assistance or just kind of peer in. And it was in that moment, in that case, I realized this is it. This is how I want to help people. And it may not necessarily be domestic violence, but it's people that are victims of violent crime. I want to be able to give their voice. I want to be able to be their voice for those people that can't speak up for themselves. So it was in that moment that I realized this is the trajectory that I'd like to take. But I got to go through the grunt and all the misdemeanors, and I got to work my way up in the office. Okay, so fast forward, I'm living here, I'm working for free for 8 months, and my money's running out. So I go to the office and I go, I can't do this anymore. I gotta go be a bartender again or something. But you know, I'll see you when you're hiring, because they still weren't hiring. Well, you know, magically the county comes up with some money, and even though it's a hiring freeze, they can still pay me as a temp employee. Okay, keeps me going, awesome. And then eventually, after I've been working for 1.5 years for free, they finally open it up for hiring, and I have to interview like everyone else, even though I have a full caseload and I'm literally in trial, and you know, it's just comical. But that's what you have to do, I feel like. In this day and age, jobs aren't easy to come by, and once you know what you want to do, keep at it. I mean, I was offered other things along the way, but I knew this is what I wanted to do, and it's so worth it. So finally, get dream job, living in my dream city that I want to live in, and work my way up. So I've done misdemeanors, I've done, kind of they do general felonies, preliminary hearing assignment, grand theft auto, some filing time where you just file, and domestic violence, and now I'm in my dream job, to be honest. This is always, as what I've realized along the way, this is exactly what I want to do. And I can't be happier in my life, to be honest. Be able to handle sexual assault, child abuse cases. It is the most gratifying thing that I can tell you that I've ever done in my life. For example, I can't tell you about my open pending cases. I can tell you about closed out cases. So I want to tell you about a couple cases. But I mean, for example, yesterday I'm meeting with two brothers. One is 14 and one is 11. Their sister was sexually abused by their grandfather for years. And I am meeting with both of them, with my investigator, with my victim advocate. And as they are pouring out their hearts about what they've witnessed with their sister, I am able to stop them and talk to grandma, who's in the same room, other grandma, and go, okay, let's get some counseling. Let's set up some services. What can we do to set that up? And to be there in this environment where I've got my victim advocate, I've got everyone present to be able to actually assist these kids is one of the most powerful things possible. And then for me, I get to actually walk into court and hopefully prove the case, which has a lot of overwhelming evidence against him, and know that this man is never going to be able to do that ever again. Not to her, but not to another family member, and never to anyone else. And that is, it's just one of the most powerful things, at least for my life. And I hope that every single one of you finds whatever it is you're passionate about. I'm not here telling you be a DA. I'm here telling you find what it is you're passionate about. And find where you want to live. And figure those out together. And push and save and do what you need to do, because it's worth it. It's so worth it to be on the other end and to have made it work. So with that, I wanted to talk about kind of a couple war stories, right? Those are the interesting stuff. So I can talk about my closed out cases. I'll talk about a couple domestic violence type cases that I have that I think are interesting. How am I doing on time? Okay. He's like, whatever, you're fine. All right, cool. I like it. So, like I said, my goal is to help people. I don't always get a feel-good feeling or feel that I'm, the victim may not always want my help, especially domestic violence, right? One case that I had, it was February, went to trial on it. The victim and her longtime boyfriend, baby daddy, were together for at least 10 years. They have 3, maybe 4 kids together. Wasn't clear if the last one was his, but either way, they have a really bad relationship, if you even want to call it a relationship. He was in prison for, I think, 3 years the last time he beat her up, and that was actually out of LA. And then this time, there's a current no contact criminal protective order in place, except he didn't care, and proceeded to basically, this was it for whatever reason. This is going to be the time he finally kills her. And they're in their trailer together. He goes out to go take her car. And I don't think he had any intent of hurting her at that point in time. But at that point, he just wants to take the car and take off. So he does just that. He gets in the car, and he steals her car all the time, and she's just sick of it. So she's a little radical too, and grabs a hammer out of the house and proceeds to basically run after him as he's backing out of the driveway. It's like a big Yukon SUV. She jumps on the what's that called? The sideboard, you know, that you jump on. Anyone bring on? I couldn't remember a trial either the whole time. It was terrible. So the running board, she jumps on top of it right next to the driver's door, knocks out the window, the driver's window. Some glass flies in at him, so he's got some scratches and some blood on him, so now he's pissed. He then proceeds to grab her and grabs the hammer from her and starts hitting her in the head with it, knocking out teeth. Hitting her, and then the hammer falls. Meanwhile, he grabs her basically from her like bra straps and grabs her and is holding on with one hand, pulling her in. And he was hitting her with the hammer with the other, throws the hammer down, he reverses out, and then basically peels out. There's a brick wall. It's right like this. He's come out, and now he's driving like this, still holding on to her. He then witness sees, thank God there was a witness, sees him basically pull the wheel and then pushes her and pulls the wheel back in and pins her, drives over her. She's basically roadkill. He thinks that she's done. He takes off. He's found about an hour or so later with the vehicle abandoned in the sand, and he is swimming in some guy's pool. Because it's hot out, you know, and that's what he cares about. She was non-cooperative with prosecution. She lived. Let me start there. She was in the hospital for approximately 3 weeks. She had more than 300 stitches. She had life-saving surgery that day. She had a ruptured pelvis. She had I'd have to look at the medical records again, but it was bad. You can imagine, missing teeth, just, this woman is as bad as it gets. Our office, we file it, attempted murder. We are trying to contact her, my victim advocate is trying to contact her while she's still in the hospital. As soon as she's released, within 2 days of her being released, we get a hold of her. She's non-cooperative. She said she made it all up, and she's the one, you know, which is typical, right? It's like, I ran into the doorknob, you know, she's trying to put the blame on herself. We take it to trial. So in February, we finally get to trial, and she takes the stand and lies through what remaining teeth she has, ironically, right? I know. She, up through the entire time of that case, she fought me. Whole time. She had to be basically subpoenaed, brought in. I refused to bring her in handcuffs because this woman has been victimized enough. Thankfully, I had those witnesses that saw, those third-party witnesses, and they were able to come in and describe exactly what happened. He was sentenced pretty quickly. He is doing he gets an 18-year term. Prison is what the judge sentenced him to. On the day of sentencing, because it's set after jury trial, she was present and had an opportunity to speak. She brought his 4 children with her to court. I don't know if it was just to see dad last time or what. And even that last time, she pleaded for the judge and said it was my fault. He didn't do anything wrong. Please don't let this happen. Please don't do a restraining order. I mean, literally the last, and she still doesn't even have teeth as she's arguing this. It's absolutely insane. As much as it killed me to have to put her on the stand and to have to fight her through it, it was still the right thing to do. Because that man, at least for 18 years, won't be able to hurt her. I have no doubt that when he is released, he will actually kill her if he knows where she is. But at least for those 18 years, she's safe. And the kids are safe. Those kids, especially the 1, 2, 3-year-olds, they might have a chance at a normal life. It feels strange to say, but it's the most gratifying thing to be able to know that I am making a difference. Even though that woman hates me. She hates me, or at least she says she hates me. I don't know how she feels when she's at home by herself and she's safe. She probably feels differently, but she'll never tell me, because she can't. Because it's not safe to do so. So sometimes that's the deal, right? I don't get the thank you from the victim. 9 times out of 10, I don't get the thank you. I'll give you one more war story, and this is the time, this is the one time, it's the 1% of the cases where I actually do get a thank you. And it's even more rewarding, you can imagine. So there is a case, another domestic violence case. The defendant, he has a long history of domestic violence, whoever he's with, right? That's what he knows, that's whatever. He actually meets this woman online through Facebook, and she lives in New York. He convinces her to come out to where he lives in Cathedral City, Desert Hot Springs area. She leaves everything she knows and comes out to see him. And the abuse basically starts right away. Within the first week, he's slapping her, he's hitting her, and it's a very bad relationship basically throughout. But she's stuck. She doesn't have money to get back where she needs to be. Meanwhile, she has a very interesting mental condition. You've all heard split personality disorder. It's called dissociative identity disorder now. And we all think, oh, it's how we see it on the TV. No, it's not that way at all. But it's actually a lot more common than we have any idea it really is. I had to learn a lot about it as a result. but this is the condition she's had, and she's had it for probably as long as she's been alive, and you can imagine she's been through a lot. To develop that type of mental condition, you usually have to be sexually abused basically from infancy and repeatedly. And it's a defense mechanism that your brain does to, because you can't deal with it. You don't want to deal with it. So she actually doesn't have a lot of the memories, or that alter, as they're called, doesn't have those memories. The other ones do. So he learns this about her. I think he probably knew it before she moved out, but didn't understand the extreme of how it was. And he probably thought that she was the perfect victim because he could get away with anything with what she has, which is true. About 5 years into the relationship, he strangles her to the point where she actually urinates on herself. She goes unconscious. She's really close to dying, but she's a fighter and she doesn't. That case ended up being pled down to a misdemeanor because of her issues, because of her mental condition. The doctors basically said she's not believable. Even though, there's the physical evidence, they couldn't be sure that maybe she didn't do something, right? And for whatever reason, that wasn't my case, but that's what happened. No one believed in this woman. No one believed her. She hadn't been fought for her entire life, and here she is. The most recent case of domestic violence happened about, it was January of 2018. And it actually was one of the lesser of the domestic violence that he committed against her. Basically beats her up. She's got some bruises kind of all over her because it's consistent in their life, unfortunately, her life. So she, for whatever reason, I don't know what it took, but this was the moment in her life where she decided, I'm not going to take it anymore. I've had enough, and I'm going to stand up and I'm going to do something. So she actually leaves, finally, after the weekend of kind of torture. She leaves, she goes to the police station and reports it. First thing she says when she goes to the police station is, I need to tell you something first, and you're going to think I'm crazy, but you need to listen to me, and I have basically a split personality disorder, and if an alter starts talking, I need you to disregard that person, because who I am, this is what I need to tell you. And she's able to get out her story to the officer. The officer doesn't really give her much time of day, thinks, well, this is ludicrous, how in the world do we prove this, and he has to submit it. Domestic violence cases basically have to be submitted if there are injuries, and she had bruises on her. So it was submitted to our office. It was filed. We just filed as basic domestic violence. Ironically, the DA that was supposed to do it was in trial, and she was going forward to a preliminary hearing. Are you guys familiar with preliminary hearing? Okay. So it's a very early stage of the case. The case has only been around for about 2 weeks at that point in time. And I'm very grateful that the DA who was assigned the case happened to be in trial. So I was next to her office and I said, I'll do it, no big deal. And then I start reading it and I realize, oh man, we're gonna have some issues. And I start realizing the history of everything and realizing just how much of a victim this woman is and the fact that no one's believed her. So she comes in, we do what's called a live preliminary hearing, meaning that she's actually in there testifying instead of the officer just saying what she told him, because I wanted to see what we're dealing with. I wanted to see, is she going to switch on the stand? There's so many different dynamics, right? She was able to testify. She was able to hold it together. I'm fairly certain that she remained, I'll just call her Jane Doe. I'm fairly certain that she was able to remain as Jane Doe the entire time. I don't know, but she did a great job. And she convinced me, and she convinced the judge, so that at least it went past preliminary hearing. And in that moment, I realized this woman hasn't had anyone. And so I started digging in, I started researching, and I found experts. There are no experts in Riverside County, or even LA County for that matter. Basically, the closest real expert on this type of disorder lives up in Seattle. And thank you, government. We don't have funding or whatever. Meanwhile, I can at least talk to him and learn everything I can. And so that's what I did. We went to trial. Defendant is difficult and basically wanted to force her to take the stand because he knew that she was going to melt down and the case would fall apart. My victim advocate picked her up. And she doesn't drive. As you can imagine, one of her alters is a 5-year-old little girl, so she can't drive. When my advocate picked her up for trial, she's supposed to be there at 9:30 a.m. and I am getting a call at 8:15 in the morning from my advocate saying she's crying. I'm pretty sure she's the 5-year-old and she is in meltdown status. What do I do? And I go, get her in the car, give her a lollipop, give her whatever, treat her like a 5-year-old because that's what she is in this moment. Whatever you can, get her in the car, get her here. She's meltdown status the whole way over. She gets to court and she is still the 5-year-old. She is switching between 3 different alters when I meet her. Meanwhile, I've had multiple conversations with her over months and she's always been Jane Doe. But she's given me all the information about the alters because she knew that this was a possibility. And so I knew who I was talking to and I was able to tell her by her name and talk to her as a 5-year-old. And the most surreal thing in my life, to be honest, just you see it on TV and you don't think it's really absolutely is. And finally able to, thankfully, because of the information that I obtained from the doctors about kind of how to deal with the stress and the right type of atmosphere, I'm able to get her on the stand. And the judge worked with me, so the jury wasn't in there, the defendant wasn't in there, no one was in there, and I was able to just get her on the stand and sit with her with the victim advocate next to her for about 10 minutes, calm her down, and she came back as Jane Doe. And it was pretty obvious she was Jane Doe again. And she was ready. We're gonna do this. We brought the jury in, and the defendant took the stand, or took his seat, and he is mad dogging her the whole time, hoping that it's gonna set her off. And she was a rock star. She said everything she needed to say. She got everything out. She remembered everything. And she did a fantastic job. I don't know if she switched at any point during the testimony. It's possible, but I don't know. Either way, her voice was heard. This was a woman who had never been fought for before. And when she left that day, we're still in the middle of trial, but she left that day, she gave me a big hug, and all that she cared about was that she was able to tell the jury exactly what happened. And that was what mattered to her, and that I believed her. She finally had someone believe her. Jury came back guilty in 20 minutes on that case. I can't tell you how exciting it was to make that personal phone call to her and let her know they believed you. It wasn't just me. You had 12 strangers from the community that believed you also. And she's a different person now. She's getting counseling. She is going to school online. We are working with our relocation services to get her back to New York. I actually drove out yesterday and had her sign the form because she doesn't have a printer, so she needs the form to be signed. So I drove out, met with her, heard what's going on, and the biggest hiccup is her cat and how we're going to get her cat back to New York. The case is over and done with. My job's done. But this is why I became a DA, is to help that woman, it's to help the kids, it's to help the people that can't help themselves. For once, the 1%, I actually get a thank you. And 99% of the time, the woman who doesn't have teeth, they're pissed off and they're mad and they're never saying thank you. But every once in a while, I get the one, and it's all worth it for that. So that's why I do what I do. And there's some fun war stories for you. I know they're not happy, but it is what it is. And this is the life this is the world that we live in. And if I can do some good along the way, that makes my life worth it for sure. So with that, deafening silence. You guys have questions? Anything? I know, right?
I have a question.
Yeah.
What does the report look like?
What does being poor look like?
You mentioned at the beginning of your talk that being poor does not look like you. So what does it look like? My
I'm sorry.
experience, being poor does look like you. And it looks like people here and people that look like me. And so I just want you to clarify what that means and what does it matter in being a DA today?
I'm sorry that I made I guess, a political statement that I didn't realize.
It's not a political statement, it's your personal opinion. What does being poor look like, in your opinion?
It doesn't look like anything.
It looks like you. It looks like me.
Right.
It looks like every single person in this classroom, in this school.
I'm sorry if it was understood differently.
I don't need an apology. I just need you to clarify what that looks like.
What did everyone else understand my statement to be? I know no one wants to get involved, right? I'm sorry that you go ahead.
I actually took it the same way she did, but it did. I think you just meant what a stereotypical thought of. It's just the envision of that. It wasn't anything meant to be offensive.
I apologize if I said anything offensive at all. It was not meant that way at all. It's just, I don't think there is a specific person or a specific way. I grew up, so let me give you some more background. How about this? I grew up in San Pedro. The city that's nearby is Rancho Palos Verdes. It's about 20 minutes away. I don't know if any of you are familiar with the area. San Pedro is, it's a very destitute area. There's some people with a lot of money
I'm familiar with San Pedro.
So Rancho Palos Verdes, you're familiar with that area?
Very familiar. I live in Orange County, so
There
I'm
you
very familiar with, very divergent communities. I'm very familiar with that, yes.
So Rancho Palos Verdes is probably one of the most affluent areas. Orange County, right? It's California. There's tons of different areas. And the people that live there all look like me that I was used to. The kids that went to my same church were all pretty much towhead, blonde hair, blue-eyed kids. And I would remember hanging out with us and we all looked the same. But they all went back to their multi-million-dollar homes. And so that's all I meant by it, was I looked like them, but I didn't have the same things they had. That was all I meant.
Yeah, let me just make a point here. And I completely understand everyone's point of view. And I think some of you know this about me, by the way, but I grew up in a black neighborhood. We were the only white people on the block. I went to a black high school, black junior school. I was the minority the whole time. Who do you think looked poor in that area? Everyone looked down on us. It didn't really matter. It's just that that's what you looked like. You have to look at all the things in comparison. You have to look at everything in, I don't know to this day if we were actually poorer than anyone or not, but we were perceived that way. So again, a lot of it is driven by the environment, and a lot of it is driven to make a point. So if I say that, y'all jump on me, you're gonna get a mouthful from me.
I don't know how to explain it other than that, is what I felt based on everyone else looking the same as me, but I knew I didn't have what they had.
I guess my point was poverty looks like all of us.
Absolutely.
It looks like you, it looks like me, it looks like all of us. And so when you come in here and make a statement, poverty doesn't look like me, it's inaccurate. And it's somewhat offensive as well, given the political climate we're in.
Well, I
And
apologize that
it's
I
something
offended.
that I feel you should probably think about.
It was a very quick statement, and I apologize, and I appreciate that. And I apologize if I have offended anyone. I apologize to you.
No, we're mistaken.
Thank you.
Just words mean things.
Totally.
The question. So you stated that when you were younger, I don't know if I understood right, but you were in like an abusive environment, and your story, it touches me because I was also in an abusive environment, and I wouldn't be able to do the job that you do. So how do you do your job coming from an abusive environment and helping kids? Does that ever like trigger anything, or I don't know, what keeps you sane?
A good question. So it's called vicarious trauma, basically, is what anytime you're around kind of what we're around, we're basically absorbing the trauma that they have, and it's like we almost have our own trauma, seeing and dealing with what they have to deal with, which is, I mean, it's a small portion of what they deal with. And they always tell you, okay, make sure to take vacations, right? Do hobbies, do things that are you. To be honest, me personally, I think because of the trauma that I went through as a child, as much as it sucks, I'm able to compartmentalize things a lot more because of it, unfortunately. That was how I was able to get through my childhood, was even though I'd been beat or whatever, I was able to just, nope, that's just what happens at home, and I'm at school now and everything's fine at school. And so my brain was able to compartmentalize things. And I know people that were abused that could never do what I do. And so as a result of that kind of defense mechanism that I built, I'm able to read my cases and completely compartmentalize them, and I don't take them home. I don't tell my husband about those cases because he can't compartmentalize them, you know, and every person is different. But I think, unfortunately, or fortunately, because of what I've dealt with, it actually makes me better and hopefully gives me more compassion for people that have been through the same thing or people that are traumatized. So, does that answer?
Yes, and I want to thank you for your
Of course, yeah.
assistance and the persistence. Yeah.
Yeah.
So, you know, you mentioned that you had an abusive childhood. What is your relationship with your parents today?
That's a good question. There is no relationship. I've tried repeatedly over the years. Written letters, calls, they're just, they're not willing, I think, is, I guess, the best way. It is what it is, unfortunately. Along the way, I left out a good chunk because I figured it wasn't relevant to this, but along the way, my mom's sister and her husband, my aunt and uncle, who never had kids and wanted kids, but just didn't, you know, wasn't in the cards, they kind of were the emotional support for me over the time. And actually, that was a family member that I lived with when I was in law school. And my aunt's my best friend. I call her every day, you know, and she's like mom, basically. And the relationship that I've had with them has filled that hole, kind of where my parents are supposed to be. And actually, 2 months ago, they legally adopted me, which was really cool. So, and I didn't know that was a thing. I went to law school and didn't know adult adoption was anything that you could do. So I actually called them at the beginning of the year and I said, so there's this thing. And they're like, oh, they broke down crying and were excited, you know. I went to law school, we figured you knew and you just didn't want to. And I was like, are you kidding? I'm just an idiot and didn't know. So, but yeah, they adopted me and it's kind of our own family that we have. And my parents are just off on their own. Last I heard, they moved to Arizona. They're on their own, unfortunately. I'm hopeful maybe someday, but for now, it is what it is. Anyone else? Yeah. Sure.
I know you said you were working 5 days a week your third year?
Yeah.
And then going to law school, which is the situation for most of us. So I just want to know if you have any study tips. I know especially third year at the bar, so or like study tips to bar prep or
sucks. You don't need to sleep much, right? You can live on lots of coffee and you don't need to sleep much, right? I would do, I'd work from 8 a.m. until about 3 or 4 because then I had to commute to the night class, which usually started at 6 or 7. So when did I study? Weekends? I mean, I would start on my syllabus as soon as I got it. Like, we had normal season, right? So we started in like August or late August. So as soon as I got the syllabus, I always tried to be 2 weeks ahead. So as soon as I got it, it was 2 weeks, and then that built in my buffer. Is there some magical answer to your question? Probably not, other than you don't get much sleep and you work really hard. And weekends, I mean, and do something that unplugs your brain for even just an hour a day, but you need to do something to unplug yourself. So for me, I joined a gym and was like, okay, I just need to go run for an hour to unplug from the craziness that this is, so that then I'm recharged so that I can get back. So, good luck.
Okay, one more question, then we have your professors.
Sure.
Thank you for sharing your experience, your strength, and your hope. My question is more, obviously you're a champion for those people that can't speak up for themselves and all that. Where do you see yourself in 5 to 10 years from now?
Good question. I'm not sure what team. No, just kidding. This has always been my career goal, was to be doing this. And so as of January, this is when I rotated to this assignment to handle these type of cases. I've been doing domestic violence for a while, so I'm doing this. And so I'm enjoying this ride as long as I possibly can. I'm going to burn out, though. These cases are intense. They're really intense, and it's going to burn me out after probably 5 years. I might make a switch into kind of transitioning into homicides, something like that. But to be honest, I'd probably like to be a judge, and that's what I said I wouldn't want to be taped. But I think that's the natural transition, and I think there's so much good that can be done, and to see both sides. And hopefully I'm seen as a prosecutor that's reasonable, and I'm not someone that, or I don't think I'm someone that railroads other people. I go on the cases that there is, I can prove beyond a reasonable doubt, that I have no doubt that it happened. And I'm not someone that's kind of just trying to get a conviction to get a conviction. Like it needs to be ethical. Yeah. And so for me to be a judge, I think would be phenomenal, to be able to see both sides of it and hopefully to do the most good. I really think the judge has the power to do the most good for the most amount of people. So that's what I'd like to do. We'll see if it ever happens. But meanwhile, I am so happy where I am. So, yeah. All right. Thank you for having me, guys.
You know where you're supposed to be, because I should go. How long? She's very good.
Thank you again for having me. I appreciate it.
Take everybody's experience is their experience. And she's always talking about her experience. You see it firsthand.
Yeah.
Experience to be able to personalize it. I mean, I'm doing this. I say,
Yeah, it seems like everyone was interested.
I mean, but I can understand where you're not.
Yeah.
Definitely probably.
Sure.
From a minority standpoint, it's not because there's some things that you are told that you look like.
Yeah.
So I can see both sides of it.
Sorry.
No.
I think I was. Like in that part, I was like.
And then you were like, oh, I go,
Yeah.
maybe it was just drawing out.
Whoa. Like, where did that come from?
So then, I kind of do is like opposite, because I was always like, people that are eight black kids, so I had to see it, and me and the black kids over there weren't for in our head. We would talk, move backwards, and then I was like, college.
No, you're good. You have to stay passionate. You know what? If you're not,
I was like, what are you talking about?
Right.
But it was like, now I can understand the perspective of it. I was like, oh, well, I have been a generation, like an old generation to grow up in that community. Parents had been with it. I can see how they see it, but I never saw myself as that. I always saw myself as, I'm not white. Usually like I'm working harder.
Right.
Sign this.
Oh, what you signing?
Everybody needs to sign the attendance for today.
It's still government work, it's still here on the FC.
My 12th grade year was only 3 months long, from August to like November. And I was
Think about it, I'm gonna have to, might come looking for you
so
again.
like I just went to a school that had, I probably was the only, I was the 7th person in the entire school. Everyone else was black. Not Mexican, it was all black.
Oh, interesting.
Maybe anything, good.
I have a question for you. Excuse me. Oh, I have a question for you.
What's her name? Is Maggie? Maddie? Yes, totally not. There we go. There we go. Girl.
And I was thinking about
Your first sorry.
Oh blossom inside.
It is. I can do it. Got it.
His the way he does that, I can never mind the same way.
Oh, yeah.
I never know where it goes.
Did everybody sign the sign-in sheet?
No.
Great.
So, what is the next?
Not to be in it was, you know, I mean, other parents, yeah, that's a rare thing. I don't see them for tricky. They start to become somebody else. So you do enjoying the story. Oh, and you have to recognize that. I thought it was very interesting. Because I didn't care.
I'm not saying it's 100, but.
Oh.
Wanted to tell us how the laws, because now kind of gives you a checklist. You know what I mean?
But I don't want to.
That was very true. It wasn't.
Because I don't want to go it's not my place, I know, but I better just shut it up. You know? Maybe I wanted to like you. No, it was there with the.
I don't know. I just keep telling myself I don't want to do
Yeah, I'm taking care of everyone and everyone's signing. So do we have Professor Sherman? I thought we did. Why am I saying Professor? Where's Professor James? Yeah, I think Professor James.
Oh, we are.
He's here. Oh, yeah. I said something.
Who pops up? Why don't you ask for $1 million?
Yeah, right. I should say. I get 2 more wishes.
We got Commissioners, are we trying to get the copies made first right now, guys, for what we're going to be doing today? So give us like 5 minutes. I will tell you the same thing apparently you guys told last Saturday. I'm giving you 100 multi-states. Whenever I do the multi-state thing with you guys, we will be using those. So if you see that Professor Gaylor is coming in to do multi-states on Saturday, you need to bring these with you. Okay? Because obviously I can't give you 100 questions because you guys won't know how to do some of the areas of the law yet. So we'll kind of pick them in little chunks. All right?
Did you just talk about yourself in the third person? I got so lost.
Or maybe I didn't see it. Were we supposed to bring any of that?
No, you guys don't need any. I'm going to give you your handout today. Okay, it's going to have 100 multi-states in it. contracts, torts, and criminal law. And we will do little bits and pieces today. I'm going to kind of give you guys a broad stroke introduction to what multi-states are, how to go through them. I'm going to give you my technique for taking multi-states. What we've done in the past is wait till you guys get close to the baby bar, and then I have to break all your bad habits and start from scratch. So we're going to start with good habits, and then that way I don't have to break your bad ones, and then try to teach you how to do this. So there is a technique to it. If you haven't seen anything like this before, I will tell you, I'm going to throw your brains completely out for everything you ever thought you knew about taking multiple choice questions. Okay, which is completely different things. So give me some, let me see if we got the prints ready to go. Are you standing near us?
No, I already. It's like, I kind of understood. I know free-floating anxiety.
Free-floating anxiety. And maybe I'm just really bad about discounting anything. I'm like, oh, I'm going to go and pass. They didn't really mean to say that to me.
Yeah.
Make us value it. Because it was the assumption that, well, if you look more blonde hair, blue eyes, they'll probably do off.
Yeah.
But I always get, do you have this bad habit of getting to bed at night and then laughing hysterically about something that happened today? But I think my quote of the day is going to be, my experience, Port looks like you.
Yeah.
I'm going to die.
Yeah.
Were you guys offended by that?
I wasn't offended.
Okay, yeah, I wasn't. And she doesn't look.
Yeah.
I'm so.
I can understand both sides too, but
It's understandable.
Yeah.
Like I thought I was.
And I'm offended by a lot. So like I'm constantly.
I'm the king of zingers. I think that might be that's
Yeah,
up there
right.
at the top. My experience for it's like you know.
Put that on your outline.
Yeah, like if this was a civil, if this was what is a civil case where fighting words. Is
Oh yeah. Yeah.
You look like poor.
Yeah.
fighting words. Don't let me close this case.
Here you come, you can't leave. No, I'm just kidding.
I really don't want to.
I'm not doing this either. We all go on strike.
All right, guys, we're going to get started. Sooner we begin, sooner we can get out of here. I gotta get back to the hospital. So, who we missing?
Renee will be right back in. So.
Let's see.
Oh, that's what.
So what?
Oh.
Really?
Dang, baby, you're awesome. Look at that.
Oh, thanks. Yeah, I was looking at it.
Holy mackerel, you need to be a tattoo artist.
Oh my God. If I was a tattoo artist, I would be. I mean, I kind of have been, but anyways.
Yeah, did you see that? She did that.
I just dude off.
Nice.
Well, I went to art school for undergrad. Yeah, so.
Can you put that on my chest?
I can do it. Sure. Not with a tattoo gun, but.
Everybody waiting for yours? For your,
Sorry?
who else are we waiting for?
Can I see it? Can I see it? That's great.
He's gonna wear you forever.
I can't believe you freehand this.
It's easy. You just start with one circle.
Or you could start making those
You can start with one circle. I know, I thought about that. I was like, dude, I should have done that
That
first.
would be cool.
Some mandala, right? Or what, some, right?
Yeah, it's just a doodle.
What else do you do?
A lot of those. What else do I doodle? A lot of just kind of abstract stuff like that that I don't have to think about.
Okay.
Six, do you want it?
He's gonna wear it on his chest.
Yeah.
You can just take it to a tattoo artist and be like,
Right?
here, do this.
We need to get you.
So just toss it out of the phone.
We need to get you drunk.
Oh, you got another friend. No friend who has it, right?
Yeah, and then just wait for you.
So you just like.
Yeah, no. I was trying to do it as a supporting argument for pushing me here.
You're welcome.
We can all, I was being selfish.
I want that too. Christ.
Contract.
Choose our Bible.
You have a sleeve, don't you? I can see a little bit.
Oh,
Do you have a full sleeve?
Oh, he does.
Oh, okay.
Tattoo.
Yeah, I want one.
That's fine.
This is nothing to analysis then.
I was hoping to get it back, actually.
Yeah, why did we send that note?
That's
If
what
we're
I'm
not
like,
kidding.
okay, you just want to go, right, because I don't have to go, yeah.
I mean, I know I did that, but I didn't.
Thank you. My cousin.
I would be so nervous to be a tattoo artist. If you make any little mistake, like,
So she does
it's on that person's body. They're stuck with it.
You don't feel bad.
She's the one.
They're drunk.
So that's they're drunk.
No,
Huh?
Some of them.
Yeah. I think you're liable if they like die. No, I don't.
All right, guys. So, my two L's. Some of this is going to be really boring and old for you guys, so sorry in advance. Okay, guys, MBEs. Who knows what MBE stands for? It's important that you know this because of some of the facts I'm going to give you about the MBE.
Multi-state bar examination.
Perfect. What does that kind of lead you to believe? That everybody across the country takes this test for the bar. Not for the baby bar, but for the bar. So when you hear things like different jurisdictions do this, different jurisdictions do that, like in contracts as well as in criminal law, you need to understand that this goes back to common law, unless it tells you otherwise. So for example, you guys are eventually going to learn about burglary. There is a modern common law and an old common law. Okay, you need to know both because the questions will sometimes say things like, under the modern viewpoints, how would this be considered a burglary or not? And you get 4 different ways to try to figure it out. So you need to know that. All the restatements and all that stuff, out your head when it comes to this part of it. Okay, it does not apply. It'll either be UCC or common law, period. You have to, it's the hardest part, in my opinion, about the first year of baby bar multi-states is remembering those common law. Okay, the other big hang up that a lot of you will have, I've talked to the professors about talking to you about this and teaching you this portion of it. I don't know if they'll make it, if they'll be able to really enforce it as much as I'm going to try to. You guys are in torts right now and in criminal law, and you've got one word that comes up a lot. Right? Intent. Is the criminal law intent the same as the torts intent? Completely different. Right? I just have to intend to do the act in torts for me to be able to do an intentional tort, right? I don't have to intend to hit you in the face with a baseball. I just have to intend to throw the baseball. In criminal law, I have to intend to have that outcome. Otherwise, I do not satisfy specific general intent. Be cautious of that. Because when you're going through a multi-state and you're going through, you've got 3 hours to do 100 of it. And as these two can easily tell you, it sounds a lot easier than it really is. It is hard to get through all 100. Unless you've got a system and a plan and a way to get through the questions. Today I'm going to be teaching you guys how to dissect a question and how to go through it and how to approach each one. As the year progresses, I will give you in-test techniques, things that you need to understand, how to create your go-back list. If you find that you're slow when you practice multi-states, how to get through the entire test and then go back and take those long questions and address them separately. You need to get 70 out of 100. Minimum. There is no cutoff. They say, oh, you didn't get this many right, you don't pass. They do on the bar. On the bar, you will have a set amount of points that you have to get out of each category. Essays, performance, and multi-states. For the baby bar, it's not the case. The baby bar, they're weighted differently depending on how you do, but there is no set point value. But here's what I will tell you. The most commonly failed part, I shouldn't say failed, the most common area people do subpar in dramatically is the MBEs. And if you can get to 70, each question, roughly once they weigh them out, is worth about 3.8 points to 3.9 points. So if you can pick up a few points, did anybody explain to you guys how the baby bar works?
No.
Okay, let's start at that point. This will make this piece a little bit more sense. I hate this way. Okay, the baby bar is broken into two parts. You get morning session, 4 essays, 4 hours. You need to average 70 points per essay. So you're trying to walk out in the morning session with 280 points. You need to get 280 points in the evening or the afternoon session, which is 3 hours, 100 multiple choice questions. But think about this. Usually each issue, when you go through the actual essay portion, the common scores that you'll get, and correct me if I'm wrong, is usually someplace between 60 and 75. That's your normal essay grades. You might get crazy and do something miraculous and pull an 80, but that's high. Okay, I will tell you that. Just don't plan on it, because unlike a regular test, you don't start at 100 and work your way down for what you get wrong. It's an accumulation test. You get points for what's on there, and they add up how many points you got. So you have to rack up the points. Like I showed you 2 weeks ago with that little rubric thing. They go, okay, you got found the issue, you get 1 point. Got a pretty good definition, you got another point. You identified each element to a fact, 3 points. You concluded out of it, 1 point. 5 to 6 points. That's what you're going to get. Okay. So think about this. If you miss one issue in the morning session, let's say you get a 65 on one of your essays, or a 60. You're now 10 points off. If you're 10 points off on one essay, and you do good on all the other essays and only get 70 points on each one, you're still 10 points off. That's 3 multis. If you can pick up an extra 3 multis, you can bump your score up. Okay? So if you do great on the essays in the morning and you get straight 70s, and you only get a 60 in the multis in the afternoon, you fail. You're a retake. You get 68, you fail. You're a retake. Most common, most likely. So the goal needs to be at least 70, and I say at least because you can rack up makeup points with your multis in the afternoon for what you miss in the morning.
Did they tell you how many you've missed?
When you're done, no. You get you submit it, and you get a letter in the mail about 2 months later now, right?
So you have to know in your mind, like, oh crap, I failed 10, 15.
You don't even have to know that. You just have to be saying, I need to get as many multis as I possibly can. Okay? You gotta have that mindset. You can make up points with multis. All right? A great essay will still only get you 70. A great afternoon in the multis, you could get an 80. An extra 24 points.
So since you're saying rack up points, it doesn't start off with 100. Can we just choose the ones that make sense to us in the multi? Like
No, you have to do all 100.
Oh, but no, I'm saying if you don't finish all 100.
We'll address how to get through that. So, you guys kind of follow with me right now why the multis are so important. And it's most commonly, and I hate to say this, but ladies, you will have the hardest time with them. Typically speaking, from the reviews that they've had, women typically struggle the worst with the multis. They're better at the essays. Men, you will be worse at the essays and better at the multis. Okay? I don't know why. It has something to do with brain size and all that stuff. I'm not a shrink. Don't claim to be one. But that's statistically what they've shown is women have a harder time with multis than men do. Men will have a harder time with the essays than women do. Just statistics. So, what I will tell you though is that if you practice the technique I'm going to teach you, it will make it better for you. The reason being the bar tries to trick you. Remember, the essays are subjectively read. Somebody sits down and reads your essay, ticks off little pieces of paper and says, I think this is a 70. And they don't have to justify their grade if it's anything over a 60. So you can't say, well, I got a 65 and I think this was a better essay. So sad. We're not rereading your shit. That's not gonna happen. Okay? You just take your grade and you walk away with it. So you could write a great paper. You know, if the bar grader that day is having a bad day, you can get 65. There was an old story that Dean Drucker will tell you at some point in time that he knew a bar grader that would grade 1,000 papers during a Dodger game. He told her. And if the Dodgers won, everybody got good grades. If the Dodgers lost, everybody got bad grades. And nobody can challenge it. The multis are not subjective. You have to get the right answer. If you get the right answer, nobody can come back later and say, we didn't really get it right. We were going to take it away from you. That's how it works. So they have to set up systems and schemes within the question and within the answers to really test if you know what you're doing. And they'll throw red herrings in there. They'll throw stuff in there. They'll make up legal terms and put it in there. You'll be like, I have no idea the answer to this question, but I've never heard of this, so this must be the right answer, right? Don't do that. You don't go to the answers to get the answer. That's what I'm going to be teaching you. My technique is this. When we get the pages in here, you're just going to take your hand immediately and cover up all the answers. Do not look at the answers. Second step, read the call of the question. The call of the question is generally the last sentence of the question. If it's not the last sentence, it's the second to last sentence. Okay? The key factor to that ties in with the next thing. Mark the hell out of your paper. Last year's baby bar takers, I sat down and came in and they did their first sample questions with me, and I looked at it and told them all that they were in trouble because they weren't marking up the pages. How can you go through 100 questions? Think about this, 3 hours, 100 questions. That means you've got a little over 3 minutes to do each question. Some of these questions, the essay portion of the fact pattern can be as much as 3 to 4 paragraphs long. How can you read 3 to 4 paragraphs, retain everything you just read, reach a legal conclusion, and fill in the bubble in 3.5 minutes if you do not have a plan? Your plan needs to be to mark up that question and that fact pattern. So that's step one. The first thing you do when you read the call to the question, why is it important? Who cares what you're doing? Why is it important? Because now you know what area of the law you're being tested in. You don't have to think about it. You got to take the thought process out of it. So let's say you've got a number one, blah, 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 blah. Can John be found guilty of burglary? What do we know? We're in criminal. So I put a C up here. Next thing, we're talking about burglary. I'm going to do a B. What are the elements to a common law burglary? You guys don't know it. One of you spout it out.
The breaking and entering the dwelling house of another at nighttime with the intent to commit a felony or theft therein.
Nighttime. You don't be therein. Those right there are your elements to a burglary. But you will learn, what you will learn is as the year progresses on, there are two types of defenses in criminal law. There are elemental defenses and there are affirmative defenses. Big difference. Elemental means there was no crime. I am missing one of my elements. It's not in the fact pattern. It was not satisfied. If it's not satisfied, do I have a crime? No. Affirmative defenses are going to be, I did it, and I did all of them, but I have a good excuse. And my excuse is this. That's called an affirmative defense. Elemental defenses always trump affirmative defenses. Think about it like a trial. If the defense or the prosecutor never can prove that all the elements are satisfied, what's going to happen? Dismissal, right? If they're all there, then I, as the defense, have to come back and say, but wait, Your Honor, yes, he did commit the crime, but here's the reason why he shouldn't be guilty and shouldn't be punished, whether it be necessity or whatever the case may be. As you're going through this, if you're reading the fact pattern, you should be doing this. Ready? Okay, I got Bobby. Bob's walking down the street and he sees the door of the house and he opens the door. Breaking. He walked in. Entering. It wasn't his house. Dwelling house of another. Or dwelling house of another. It was 4 o'clock in the afternoon. Oh, I don't have nighttime. And he went in with the intent to steal the TV. But what they'll do is they won't say 4 o'clock in the afternoon. They'll say it was daylight out. And you'll miss it because there's not a time. You see a time, you'll think about it. If you don't see a time and it just says it's daylight out, or he was taking a walk on a bright sunny day, I now know I do not have nighttime. Can Bobby be found guilty of burglary? No. And if you aren't marking up your page and making notations about these long fact patterns as you read them, you will miss one. And you will get it wrong. So 2 huge factors that you need to take away from this. Number 1, mark up your page. Number 2, when we've talked about definitions in class, I keep telling you, know your elements. You've got to know your elements. If you do not know your elements, you will fail. And you need to be able to spout them out quick, like she did a second ago for burglary. Not even her class anymore. They need to be so ingrained into your brain that you can spill them out and just puke them out on command. Burglary, all on the page, okay? And you've got to be in that mindset. In torts, negligence, when you get to it, you need to know every element to every defense. Negligence on the torts portion of the NBEs is about 40% of the questions you will get. The rest of them, you're going to get about 10 to 15% in your intentional torts because they love to test IIED for some reason. You get a couple on defamation, a few on nuisance, and a couple on defenses and remedies. But that's the majority of your points. Criminal law, 30 to 40% will be on intent. Whether or not you know specific intent, whether or not you know general intent, whether or not you know the defenses that come with each one, and whether or not you know how to apply them to the fact pattern. Okay? Contracts, they love formation. They love statute of frauds. Those are the hot tickets. So, and the willingness to be contractual, is there really a contract? Right? That's where your meat and potatoes are. Typically speaking, which they will tell you is true, your contract multi-state questions are ridiculous. They are long, they are convoluted, and they don't make any damn sense by the time you get to the end. Half the time you don't even know where you're at in the contract. You got to go back and reread the thing if you're not marking it up, which is why you mark it up. If it's contracts, the next thing you do for yours is, the one caveat, you don't go straight into the issue. You do UCC or common law, because you need to keep your law right. What if it's an offer question and you forget that you're in UCC and nobody talks about price? Do we have a contract? Yes, we do. If you're in UCC, the only thing you need is quantity. Right? Got to know that, because that's an easy one to miss. They give you everything in there and they say, but they didn't talk about price. Is there a contract? Yes, there is. But if you're in common law, you're not. Firm offer rules, merchant rules, performance issues, timely performance, higher standard of care. These are all things that you need to know the differences between UCC and the common law. You don't have time to think. You have to react. If you're thinking about the multi-state, move on. Go a different way. You do not have the time to sit there and think about it and reread it twice. If you read it twice, you're going to miss the question someplace down the road. You will not have the time.
You said with for contracts, UCC without a price is a contract?
Mm-hmm. Only thing you need in UCC is quantity, right? I know how many I'm shipping. Everything else can be filled in with boilerplate. Right? I don't have to have anything else. And that's an easy one to miss because they'll identify the item, they'll tell you the quantity, they will give you all the other factors, they'll give you all of Q-tips except for price. And you're going, no contract, no price, yay! Moving on. No, sorry, that's 3 points you just missed. Because they will tell you, they set this room up. Was I not right about the way that room is in the afternoon? It's set up to mess with you. It's the afternoon. You just got through spending 4 hours doing the essays in the morning. Your brain is mush. You're tired. You go eat the wrong food at lunch. You come back in. They've lowered the lights. The air conditioner is really, really loud. It's usually cooler in the afternoon than it is in the morning session. And you have these air conditioners that do this the entire time. And it's dead silent because everybody's doing their best. And about 45, 50, you start doing this.
I don't even know.
It's true, I'm telling you right now. By the time you get done with the multi-stage, you feel like you ran a mental marathon. You will be exhausted. And they will hide the right answers. Most of the time, you're going to see yes, yes, no, no. You're going to have 2 that say yes and 2 that say no, whether it's a contract or not a contract, a crime, not a crime. They'll give you 2 different reasons. So what do you think the first thing you want to know is? After we know the law, what our issue is, the next thing we're looking for now is yes or no. Is there a valid contract? Well, I'm reading this, I read the fact pattern, yes, I've got a valid contract. We're down to 2. Right? We've narrowed our answers down to 2 answers. Why is that important? It's quicker. You don't have to read the ones that say no. You save 15 seconds for that long contracts question. The biggest key though is, and I told this to them, is know the answer before you look at the answers. Know what your answer is. If I was writing this as an essay, what would my conclusion be and why? Because if I know what my answer is, it does 2 things. 1, if I see my answer, I know the answer, I can move on. Number 2, if I don't see my answer, what do I know? I missed something. I need to go back to it, and I don't have time to go back to it now. So it goes on my go back list in case I get it quick. However, I will tell you this, fill in a bubble. Fill something in. Because you might not get back to it. And if it's blank, I guarantee you, you're going to get 0 points for it. You got a 1 in 4 shot, 25% of getting it right if you fill something in and move on.
So bubble it, then make a mark to know that you need to go back.
What I typically do on the test is that they give you scratch paper. No, they don't give you scratch paper anymore on the multis. You don't get scratch paper on the multis. So you go to the back of the book. Last page is blank. There's nothing there. You're going to do what I call the X column and the double X column. If you need a triple X column, you're in trouble. So the back of the page looks like, you got a page that goes like this, right? You're going to do a column and that, X and double X. This is, I think I've got it right, I'm not sure. I want to go look at it one more time. And you make your list. Every time you get one that you're not, you're like, God, I know it's yes, I think it's this one, but this one sounds good too. Put it on here. 27, 43, 57, 92, 99, I'm done. Holy crap, this is a page-long fact pattern for a contracts question with 2 questions for it. I'm not even attempting this mess right now. I'm going to pick a bubble, and I'm going to come back to it if I get through everything else, and I really do have the time. 18, 45, usually about 76 to 77, they'll do one like that, and that'll be it. About halfway through the test, when you start getting tired, you'll start finding you get these really long fact patterns. It's them messing with you. They're trying to put you to sleep.
Can we start at the last one and go the other way?
So they're going to be at the midpoint the same way. You can do it any order
But
you
you
want.
said the first ones are shorter.
Typically
Yeah.
in the beginning, and it works its way up, but in the middle, you're still going to get the really long ones. They put the middle.
Oh, in the middle.
In the middle, they put the long ones for you because they're trying to make you even more tired than you already were. You're going to need another spurt of them right around 74, 75, 76. Because they figured you maybe you got your second win, now we're going to crush your spirit. So, you got to know the psychology of the test. Do not waste your time reading that long one if you can only get 2 points and you're going to burn 4 questions worth of time on it. When you're done, you look and see how much time I got left. I got 15 minutes. Guess where I'm going back to? I'm going through these. Why? Because I already think I got the right answer. I'm just verifying that I saw something in the fact pattern that was there. Now, here's the kicker. If you don't mark up your question and you don't make your notes off to the side, guess what you now have to do? Reread the whole damn question. If you've made your notes, then you can go back to it and go, okay, I was worried about consideration. Let me see if I got proper consideration here. Or I was worried about if it was at night or during the day for a burglary. Let me go make sure it was at nighttime. Or I was worried if there was scorching, a mere scorching versus a charring when you get to arson. And you go back and make sure, and you've got your notes there, and you put a little question mark next to the element that you were worried about, and you move on, and now you're coming back just to make sure, oh, yep, there it was, I'm right. I don't have to erase anything. If you still, by some miracle, have time, then you go to your double X column. And you address those 4 questions that were super damn long that you did not waste your time with, but you filled in something. You go back to those now if you have the time. If not, you're rolling the dice. But here's the thing. Let's say you got 5 that are super long, and you guess at all 5. Odds are you're going to get at least 1 right, right? Scientifically, you got a 1 in 25 or 25% chance. If you got 1 right, you're starting at 99 points available, right? You're going backwards. So you've not wasted time. Is it better to guess at 5 and get only 1 of them right? So now I'm sorry, you're at 96. And only get 1 right, or is it to get to the end and find out when they go, because they give you the time to really, I think giving you the time is a really screw. But they say 15 minutes to go and you're at question 60. Oh shit. Right? You're doing C as fast as you can to get through that test. Because you don't have time now. You're host. And then they give you another heads up that I think you get 1 hour remaining, 15 minutes remaining, 5 minutes remaining, 30 seconds. Really? 30 seconds? Okay, that's cute. Time. Drop your pencils. And you're done. It's over. So is it better to move past the 4 or 5 or the 5 or 6 long ones and guess at them and run the chance of only getting 1 right? Or to get to the very end and have to just bubble in 10 to 15 because you didn't listen to me? Right? I like my odds better if I skip those really long, nasty ones and didn't get all convoluted. Because guess what else happens? You read that big, long, nasty one, you have no idea what the hell you just read. Now you're tempted to read it a second time, and you're freaking out, and you just want to guess and move on, and now what are you doing? You're thinking about that question for the next 5 questions. Oh, wait, maybe that was... Really? And now you're not paying attention to the rest of it. It's in your head. And you're already sleepy. You're sick and tired of hearing the groaning sound or the damn air conditioner. And the poor girl is sitting 2 seats down from you started to cry about question 45. You think I'm kidding? We got a guy who literally had a nervous breakdown. They had to escort him into the hallway. He was screaming at the proctors. Well, shit you not. It's the test. And they will tell you when you come back in the afternoon, you're going to see a lot of empty seats where people were sitting before.
You said that you had made a comment, like you ate the wrong lunch or something. Would you suggest eating if you're not hungry?
Yes, you need to eat something to stay away from carbs. A couple carbs, but not a lot. Why? Because carbs make you tired. They weigh you down. You need to eat some fruit, some protein, a little bit of clean carbs, and go back into the test. I suggest if you're going to eat carbs or if you want that energy rush, eat some sweet potatoes. You say do, but they got sugar in them, which will give you a little bit of energy.
So you wouldn't suggest taking a nap?
No. No. Are there any smokers in this group?
One. Yeah.
Who's my smoker?
Yeah.
Okay.
Bring back or something?
Go get some nip.
Yeah.
You can't have candy or anything in the room. You also cannot leave the building.
Okay.
So my suggestion is, because I used to be a smoker, go get some little Nicorette lozenges.
Yeah.
Show them in your pocket. When you start getting the Jones, go to the bathroom.
Yeah.
Pop it in, come back out, and don't make any noise.
I appreciate that. Thank you.
We have a full day before you guys go in where I tell you all the little tricks you need to. I even draw you a map and show you where the shit is, how to get around, where to go do stuff. Because it helps. You're walking in up there. Guys, give me a second. This is my mom. She's at the hospital. Hey, Mom. Hello. That's why I wasn't here, by the way, guys. Thursday night, I tried not to miss classes, but my mom got admitted to ICU Thursday morning. So we're waiting to find out she's mapped out heart surgery and pacemaker put in. So I will give you guys the whole lay of the land because you've got about, what is it, about 2,000 people, it seems like? 2,000 to 3,000 people. They're all freaking out. They're all nervous. People are whacked out of their brains, walking around in circles. You get funneled through this almost like a herd of cattle getting funneled through this 3 little doors with your piece of paper and your plastic bags, and everybody's freaking out, making noises, and you're like, what the hell? And you're freaking out now because you're like, oh shit, did I bring enough pencils? Do I have all my, proctors are no help. You get, like I should say, you can get lucky and get a really nice little lady every now and most of the time they're useless. So it's nerve-wracking. It's absolutely nerve-wracking. You need to have a plan for the entire day. Plans for essays, plans for multis, plans for lunch, plans for breakfast, where to go smoke, where to go do this, the whole gamut. Okay, and as we get closer to it, I will give that to you.
Do you know anything about applying for special accommodations?
Yes, there is a program for special accommodations. If you're going to need that, you need to file it soon.
Okay.
Not like right now, but I'm saying you need to file it earlier than your deadline dates.
I don't think the application is available until March 1st. But do you know how tough it is to get the accommodations?
You're going to need stuff from your doctors.
Right, yeah, I can get that. Okay.
If you get stuff from your doctors, you'll probably get some kind of accommodation. Typically what they'll do is they'll give you extra time in the morning and extra time in the afternoons, depending on.
Yeah, I would like extra time in my own room, if possible.
So, and I'm telling you guys right now, it is nerve-wracking. Am I wrong?
Oh, absolutely.
And this knucklehead wasn't going to drive up till the morning of, and I threatened to whoop him. And aren't you glad I threatened you?
He's absolutely right. There's 2,000 people going to the same Starbucks, going to the same Subway, going to the same little liquor store to grab something. It's
chaos.
You need to listen.
Did you check the LSAT? It's like the LSAT.
Oh, God,
no.
No?
You're in one giant room with all 2,000 people. They ran out this passing in an auditorium. They open it up, and there's layers of tables all the way across from one side to the other with little wooden folding chairs. And you go in there and you find your table. You're in the middle of a row of 25 people. And then you all sit down next to each other, and they read you all the instructions, and they say, you may begin. And then when you get to the end, they say, 1 hour remaining. So we'll talk about taking watches and clocks, or how to take a watch in there with you, how to use your watch for your timing. We will discuss various things as we get closer to it. But I'm telling you now, you need to know that when you walk into the multi-state portion of it, you have a plan of attack to how to get through the questions, how to dissect the questions, and you do not deviate from your plan. If you deviate from your plan, you will fail. The questions are designed to not make it easy for you. They are designed to try to trick you. They're done that way on purpose to know if you can do the basic standards, which is identify the issue, know the elements, apply the elements to the question, and move on.
If you're like sick, do they let you take it? Like you're sneezy?
Oh yeah, oh, of course.
Oh my gosh.
Yeah, guys, it's a mess.
Do we need an accommodation for like earplugs or no?
No, you can take earplugs in with you when you go in. My advice when you guys start doing your Saturday writing samples and exams is experiment with wearing earplugs. I can't do them because I've got injuries in my ears from the military, and all I can hear is the ringing tinnitus sound, so it drove me crazy. So I don't use earplugs. But I would try them out, experiment with it. One key thing I will tell you to do is at least once every couple months when you're doing your essays, practice doing them manually, meaning ask for a blue book and write it instead of typing it. Because if your computer goes out in the middle of the test, that's your option. That's it.
And they don't supply you with computers, correct?
You bring your own computer. And if you forget to upload exam stock before you take the test that day, you're screwed. There's no internet in the room or in the building. So you cannot install it now. So just being honest with you guys, you need to have a plan. So that being said, let's take a look at the multi-state package you were doing. This is out of a program called PMBR. I'm a huge fan of PMBR for bar takers, not for baby bar takers. As you guys get closer, PMBR taught the same program that I learned the system when I went to military prep school. In military school, we had an entire semester on standardized test taking. The psychology behind it, how to look at the questions, how to dissect the questions. A lot of what I'm teaching you is the techniques they taught us to do for things like the SATs and the ACTs. Okay, that's where I developed this, or that's where I got this system, and I have learned over the years how to apply it to different tests I've had to take. I got 149 out of 150 on the ASVAB when I took my ASVAB to join the military. Scored the 99th percentile of the GTs. I am not that smart, guys. I promise you I'm not that smart. It's knowing how to take the test. It's understanding the techniques for standardized test taking. You've usually got one right answer, usually. You have one answer that's apparently and blatantly wrong. And then you usually have two that maybe. One of those two that's a maybe will be a red herring. They'll give you a fact or they'll infer something that's not the case to make you pick it. Okay? They won't say, no, there was no burglary because it didn't take time or take place at night. They would say it was a burglary because he entered the dwelling house of another. Wow, okay, that sounds pretty good, right? Because he did, that's an element. They gave me the element. Cool. But they didn't talk about the one that they didn't tell you about. Okay? The test is designed to tweak with you. I promise you this. So we're going to look at this program. Kaplan's the one, Kaplan bought out PMBR. PMBR was the one that used to teach the course that I went through way back in the 90s. Okay? If you stick to it, it changes everything you've ever done for multiple choice questions. So all through high school and college, when you got a multiple choice question, what did you do? Read the question, read the answers, and picked the right one, right? Okay, those tests that you took in college and in high school were not designed to trick you. You cannot apply the same plan and the same methodology to a test that's designed to trick you to one that's not, because you will find multiple answers that look right. There'll be questions in there that you might see all four of them. God, these all sound pretty good. Oh shit, now what do I do? So the difference is we're going to know the answer before we read the answers. We're going to know where we want to go. We're going to have that plan in place. All right, so let's go to page, we're going to start in contracts. Now I'll ask you guys some questions at the break, and I'll pick out some questions in torts and in crim law as well. So I want you guys to go to question number 2 in contracts, about halfway through. And I'm going to do on my paper, I want everybody to stand up and come over here by me. I want you guys to watch what I do to my page and why it's important. Number 1, I cover up all the damn answers. I don't want to be tempted to read them. I don't want to glance down and see something and put a preconceived notion into my head that does not exist up above. So, if the neighbor thereafter mows the man's lawn, will he recover the $50? Okay, that doesn't tell me what the area is. I can assume it's contract, but I don't know it for a fact. I want to make sure. So I come up with one sentence. I hereby revoke my offer. Okay, we're in contract, right? I put my K. A man told his neighbor, if you mow my lawn, that's going to be common law. Why? Because that's a service. I will pay you $50. Unilateral or bilateral? That's a unilateral contract, right? You do the act, I pay you. So I do my unilateral. The man then purchased gasoline for the mower so he could mow the lawn, getting close to taking a substantial step. The neighbor wheeled his lawnmower over to the man's property and started the engine. I started walking across the bridge, right? I've made that first step. I've done enough substantial that I can say, I think I've got an offer. It's been accepted. There's valid consideration. The man should recover. That man that suddenly yells, I hereby revoke my offer. Invalid revocation, right? You can't revoke once I started on the unilateral contract. So, is the man mows the yard, will he recover the $50? Yes, he's going to recover the $50 for his offer, acceptance, and consideration. Unilateral contract, and he's performed. Yes, because there was an offer for a unilateral contract that became irrevocable prior to the man's attempt of revocation. Wow, that sounds a lot like my answer. Now, if you didn't mark that up, you're not sure. Unilateral contract. What was the rule for? Was it unilateral contract? I got to go back and reread them. I've wasted time. And if I just read all the answers, my next one I see is yes under the doctrine of quasi-contract. What the hell is a quasi-contract? I don't know what's going on, but I know it's a yes. I think this guy should recover, but I'm not sure. Okay, now I'm confusing myself. I'm wasting time. I saw my answer as the first answer on the board. Why am I reading anything else? Because I already had it in my head. I didn't have to guess. I didn't have to pick the one that sounded right. Right? This is what I call marking up my page. I'm putting down my elements for, I know it's offer, acceptance, and consideration, unilateral contract. I've got a substantial act. When you bought the gas, maybe not buying the gas, but when he pushed the mower over, that sounds a lot like a substantial step. He's started the process. Therefore, I have a contract. And it's been accepted. And that guy's entitled to recover his money. Make sense? You see the difference between just reading it and not having my notes, not going through my pattern, not having my plan. Now, when we talk about some of these questions, it can get ridiculously long. That's one fact pattern for a contracts question.
For just one question or multiple?
That one's just one.
That entire page?
From starting from here to here. Am I going to do that one first, or am I going to go put that on my double X list? Double X list. I am not reading that monstrosity. Hell no. Not right now. Okay? So, we're going to go through a couple contracts questions. I want you guys to be practicing this. All right? Let me pick another good one for you guys. 20. 20 is a good one. Go to number 20. Question 20 in the contracts portion. Keep going, it's on the back page. Okay, so what's the first thing we're doing? Cover the answers. Then we read it. With respect to an agreement between an owner and supplier, do I even need to question whether or not I have a contracts question now? No. So I can already write my K up on top. You guys have learned those abbreviations, right?
No.
Yes. C is criminal, K is contract, T is torts. Okay? Shorthand. And K is actually a shorthand for contracts. You'll see that a lot.
Say it again. C, K.
C is criminal law, K is for contract, T is for tort. There's a couple of them that you'll see sometimes as shorthands. I'll give it a couple to you now. In addition to that one, you've got, what's that? What's 5 stand for? Plaintiff. And then I got this one. What's that?
Defendant.
There you go. So if as you're outlining your essay questions, do that instead of writing out plaintiff and defendant or the people. Slapping them. Wasting time. Okay. So I've got a contract. Respect between the owner and supplier. Supplier kind of leads me to believe what? CC, right? Suppliers don't typically supply services, they supply goods. Which of the following statement is inaccurate regarding omission of a fixed contract price? Now we see the importance of making sure that we know that it's UCC or not, right? Because what did we just say a few minutes ago? All I need is what? Quantity. So I'm already going something in my head going, okay, I'm looking for the one that says I don't need price in order to have a valid contract. The restaurant ran a promotion ad in the local newspaper. Nothing I'm worried about. Mother's Day special. Still not worried. Will be open for brunch, blah, 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 blah. Still not worried. The response to the promotion was more than the restaurant expected. As soon as the restaurant was overbooked for the Mother's Day brunch. On the day before Mother's Day, the restaurant owner decided to double check his inventory to make sure the restaurant had enough food and supplies to handle the large Mother's Day crowd. To her horror, she discovered the restaurant was almost out of eggs. Knowing that a large supply of eggs would be needed for the omelet station, the owner immediately sent the following email to her egg supplier. Desperately need 20 flats of grade A. So I've got what? Q-tips, right? If you're not thinking about it, we've got quantity, time, money is no object. Oh, I'm missing my price. We've identified the parties, the supplier and restaurant owner. The eggs must be delivered today. The supplier emailed back, no problem, I'll load them on the truck and deliver them within an hour. With respect to the agreement between the owner and supplier, which of the following statements is most accurate regarding the omission of the fixed price of the contract? I know that I don't need price in order to have a valid contract under the UCC. Therefore, it's a valid contract. We also know that you've got regular course of dealings. This is her egg supplier. So we can assume that they've already dealt with the price or have a reasonable price expectation between the two of them. Because prices on eggs typically don't change too much, right? So the contract is unenforceable as it violates the statute of frauds. Oh, shut up. The contract is unenforceable because indefiniteness. Shut up. The contract may be enforceable if it's later modified to include the term price. I don't need to do that. Not C. The contract is enforceable with reasonable price being fixed to the eggs at time of delivery. Well, what do we know? That sounds like our right answer, almost verbatim to what we said. So our answer is D. Now, if you had just read all that and you didn't pay attention that you were in UCT, you didn't know that they were talking about whether or not it's about price, we know that's what? An element of a contract. It's part of our element we're required for Q-tips in the initial offer. Here's the one that really blows your mind. He's not really making the offer. The restaurant owner's not making the offer. The supplier is the one that accepts the offer, right? He's held himself out. So they can come up with the price. It doesn't matter. But if you weren't paying attention, you didn't remember that you were in UCC, and you didn't know that since they throw something like price out there, that they were trying to test me and see if I know that Q-tips doesn't have to exist in a UCC contract. Because that's what they're doing, right? Do you know that you only need quantity? Because if you don't know that, you're screwed on this question. And just think, you've got another 8 months worth of law that they're going to do this to you with. Just being honest. So, guys kind of getting a gist for the pattern, right? So I'm going to give you another question, and you guys are going to do it silently to yourself.
Quantity, time, identity of parties, price, and subject matter.
Awesome.
Did you guys get your Fleming's books or anything like that?
No, they're getting on Fleming's late now.
Oh, they're gonna get them later?
Yeah. Which I think is a good idea.
Yeah, because that kind of,
Messes you up?
that mixed us up.
Oh, it did?
Just listen. Mess me up.
I don't know if you did.
So I'll have to find those first.
You guys may not have enough in here. Let's go to a different period of law. What time do I have you guys till?
3.
Till 3?
2:30. 2:20.
Where are you guys at in the room right now?
You did?
Wait, say it again?
All of the 6 defenses, the last thing we read was defenses, right?
For which one?
Oh, you guys at Duxville Station?
No,
We
constitution.
were told to have solicitation.
Oh, for next week. Okay, so what have you guys covered? You guys get the mens rea?
Yeah.
You get the mens rea, criminal intent, actus reus, right?
We're just starting, we're doing active.
We just started active.
We're just starting active.
What have you guys done so that?
burglary.
Oh, you guys have done burglary.
Larceny, robbery, assault, battery.
Oh, okay. Burglary.
The modern definition.
Yes.
The burglary, the modern definition, is that part of the common law or is that part of the state?
Okay, so when you guys are doing burglary, hold on. You need to know both. The common law is the breaking, entering, dwelling house of another at the nighttime with the intent to commit a felony therein. Modernly is the breaking, entering of a building of a protected structure with the intent to commit a crime or a felony therein, right? So it's almost the same. If it says under the modern view, then you go with the modern one. If it doesn't say anything, go with the common law.
So on this, gonna say the modern?
If they want you to use the modern rule, you would do the modern. If they don't say anything, stick to the common law.
It says that on the instructions before you start. Apply common law unless told
Otherwise.
Or use the rule or the element, except otherwise in the question. It'll give you the element.
You guys have done all the theft crimes?
Although,
You guys have done all the theft crimes?
only those 6 I just told you about.
Okay, go to criminals at the back, I believe. Where did we find it? Okay, go to criminal. Go to question. Go to question 23. The very first page. Just so you guys know, that was all the time you got for that question. 1.8 minutes of question. What you got?
B.
Okay. I'm more concerned with this. Everybody hold your pages up. I want to see the page. You failed. You're pretty damn close to failing. You failed. Good. 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 Notice how the ones that I said good to were the ones that said they were done. The rest of you that didn't have anything marked down were the ones that were saying I wasn't done. The system don't lie. You don't have to keep looking at it. So, who's got A as the answer? Who's got B as the answer? Who's got C as the answer? Who's got D as the answer? B is the answer. B is in boy. Why? Somebody who picked B, tell me why.
Because here we have the taking and carrying away the personal property, but here the defendant took out a stick, stuck it against the man's back, and told him to give him his wallet, or he was going to shoot him. So therefore, that created fear into the victim, and that satisfies the element of robbery.
Right. Now, how many of you guys had all the elements for robbery and for larceny written on your page?
well, just robbery, but I know larceny just says missing too.
Okay. So if you have that, it makes it a lot easier to get to the right answer. Anybody believing yet? Okay, let's pick another one in criminal. I'll try to get you guys out of here in about 20 minutes.
Well, I had all the elements listed, but I was like still reviewing the answers. But I knew it was robbery for sure.
Why were you still reviewing the answers?
Well, because I wrote down everything for robbery, letter form, and then I knew it was robbery, but I didn't look at the answer choices yet. I just said, okay, it's robbery. And you said, okay, look, everybody looked at it.
Okay, I'll give you that, but think about this. Why did it take you a minute or 1.8 minutes to get that far? This is a short fact pattern. I'm not being critical, don't take it that way.
No.
Just trying to get you guys to realize what's 1.8 minutes is about a minute 40 seconds, minute 42. So then, trick to slow readers, you've got to pick up speed. You got to learn how to skim for your thing. It's going to be more important for you to mark up as you're going, so you don't have to go back and relook for elements. It's going to be critical, as a matter of fact.
Question.
Yeah.
On 23, so say we're running through the elements. What's the situation where we have to pick the better answer? Because that seems like what 23 kind of is. Like, it's just the one that satisfies the most elements?
No, it's the one that satisfies. If you don't have one that satisfies all the elements, you're wrong. I don't know, you're wrong. You have to satisfy all the elements. If you don't, then your answer is no. They're not going to give you one that says what crimes can they be convicted of and not give you a crime to be convictable of. Unless they give you D, no crime at all, which you will see. Most of the time, though, for what it's worth, that's the red herring. They're setting you up to think that there's no crime. And I guarantee you, if you skim the answers first and see that before you read the fact pattern, you will find no crime. We're predisposed to not find a crime. Right? Let's see here. You guys have got 23. You guys have started conspiracy, but you haven't done it yet.
We haven't done it. Yeah, I think you just said it's like.
Have you guys did assault battery yet?
Yes.
Okay, do number 28. And go. 28. Time. Hold your papers up. Better. Okay. You won't drink the Kool-Aid, will you?
I get stuck.
Not drinking the Kool-Aid. For your elements.
Well, actually, you can look at one.
Okay. Got your elements. Okay.
Oh, sorry.
You should better have them. I'm not even looking at your pages.
Well, my thing is that I underline what I feel like is important to finding the element or not finding the element. Does that just help, or would that?
It does, but when you see something like this, okay, let me give you guys a test taking strategies like this. When they tell you which of the following crimes can be convicted of. The minute you start reading this fact pattern, I want you guys to see where the shift takes place. Ready?
Okay.
A wealthy woman often wore expensive jewelry while walking in her park. I've got expensive jewelry. I guarantee you one of my options below is robbery. So I'm going to do my R. I'm going to do my elements for robbery. And then her friends warned her against wearing such valuable jewelry because they fear she'd be an easy target for a mugging. Look, we're definitely talking about robbery now.
Yeah.
What crimes always go hand in hand with robbery? Larceny, assault and battery, because I need the force and fear, right? If I make you think I'm going to do you harm, I got force and fear, I've got an assault too, simultaneously. It's usually merged up. What crime always goes with assault and battery? So I can guarantee you if I see robbery, I'm going to have an assault, and I'm going to have a battery option as well, almost every time. So in my mind, those are the ones I'm looking for. And if I see one, here's another trick. This applies to your essays too. And this is one of the hardest things you guys will learn to do with your essays, I promise you. If you see one element to any crime, to any tort, or to any element of, or substantive part of a contract, you are talking about it. If you see, for example, in contracts that somebody mailed out an offer, even if that's not in dispute, you're talking about the mailbox rule. If you see somebody get scared, you are talking about robbery, you are talking about assault. If you, where are you guys at in torts? Intentional torts? If I see a touching, I'm going to talk about assault and battery, even if there was no assault. Why? Because there was a touching. That's one element. One element, you're talking about it. Rule it out.
Assault doesn't always have to be an element of battery, right? Because you don't.
Doesn't always have to, because you can do it from behind.
Yeah.
But if I have a battery, guess what I'm going to also talk about? I'm going to talk about assault because assault leads up to a battery. And if you have a battery, there's a chance you're going to have an assault. So guess what? I'm going to talk about it. I'm going to rule it out. However, while the hand was approaching in the back of her head, if she, by some miracle, could have seen it, it would have been an assault. But since it occurred behind her back, most likely she was not aware of the harmful or the intent to harmfully touch, and therefore there is no assault. But I got one element, I'm talking about it. And rule it out. It's points on the table that you're leaving there. Multi-states, same kind of concept. If I see one element, I'm thinking about it. And you gotta be quick. So an example in this one is, the minute I see my element, I'm already pretty sure I'm gonna have a robbery. Her friend decided to play a practical joke. One morning, the friend dressed like a man and hid in the area of the park she knew the woman customarily walked through. As the woman was strolling through the park with her dog that morning, the friend jumped out from behind a bush, brandishing a toy pistol. I now know for a fact that I'm going to be talking about robbery and assault. Already, for sure. Why? Because I got an element for both of them. I got a toy gun, so this lady's probably gonna have a heart attack. And I'm gonna go to a murder room in the essay. But I know for a fact that she's gonna be fearful. And if she's fearful and she's wearing expensive jewelry and he's gonna teach her a lesson about it, I can already kind of assume that it's gonna be a faux robbery situation. And grab the woman's diamond necklace from her neck. Well, there was my robbery. Startled, the woman became hysterical and began to plead for her life. The friend then removed her male garb and handed the necklace back to him and said, I just wanted to frighten you to teach you a lesson. If the friend is subsequently prosecuted, should she be found guilty of she should be found guilty of which, if any, of the following crimes? Okay. Do I have a battery? Yes. Do I? Or we should. Do I have an assault?
Yes.
Uh-oh, we have a dilemma. Do I have a robbery?
No.
Do I have a crime?
Yeah.
How are we going to figure out which one to go with? What are your guys' thoughts? There's a simple rule to this one.
You charge with don't you charge with the greatest of the crimes and the battery is the greater of the assault?
It merges up. The assault becomes the battery. It's an attempt to commit the battery, therefore we have the battery, which takes the assault and negates it. We fulfilled it. So you guys all got A? Yes? Okay. You guys starting to get a feel for this a little bit better?
Yes.
Guys, these are hard. I promise you, this will be one of the toughest parts of the baby bar for most of you guys. What did you get on the multi?
63.
Where were you practicing at before I taught you this? Where were your scores typically coming in? Where were you at?
I was at 5th base and I went up to 61.
And that was what, 2 weeks before the test?
Mm-hmm.
I wish he would have been here.
Wow.
At the beginning of the year.
10 points, guys. That's a big jump. That's good, especially with very little time to practice it. If you guys practice this technique, you guys are eventually going to get, do you guys get bar max yet? Okay, good. Here's my view on bar max. As we progress through multi-states and keep going forward, here's the deal. You need to put pen to paper. You're going to get a program called Bar Max that you can put on your phone and you can practice your multi-states. It is awesome for black letter law review. It is not the same as taking a book, putting it down, and practicing multi-states. By the time you get to the baby bar, you should have done at least 1,200 to 1,500 multi-states.
This is on our computer, right? Or is it going to be like a Scantron?
Scantron.
Okay, so it's paper, and the essays are on the computer.
Yep.
Okay.
You will literally get a booklet.
Okay. Yeah. Yeah.
The day of the baby bar and leave here, they literally give you a packet like what I gave you right now, except it's a bar, it's in a book, and they give you a Scantron.
Looks like this. Exactly like this.
I have a question.
Yep.
You said there was a blank page at the end of the.
At the very back of the book, the last page is usually blank.
Can you tear that out or do you?
Nope.
Yeah.
Okay.
Nope.
So we can't have a piece of paper to block out the
You're
answers.
going to use your hand. That's why I said use your hand.
That's the point.
You will eventually train your brain to not even have to use your hand. I don't have to cover them anymore. I just don't look and I don't let my eyes stray. But it takes practice. Okay, and right now I want you covering. I don't want them to be a crutch for you.
What was the app you said? Is it a website or app?
I think is it Bar Max?
Adaptive bar.
Adaptive Bar, sorry, my bad. So they give you an Adaptive Bar. It's a great, Adaptive Bar is great, guys, for practicing your black letter law knowledge. It is not good for practicing multi-states. Because if you're not marking up the multi-state, you're not learning the technique. Okay? That's just my personal belief. But everybody that I've tutored in multi-states has typically gone from 50s and 60s to 70s and 80s.
So what do we use to practice?
There's books. You get the Fleming's multi-states at some point in time.
Fleming's will give it to you.
Yeah, you get like 3 books out of Fleming's. You get the orange book, you get the blue book, and then you get the orange book, the purple book. I will tell you guys right now, these that I'm giving you are all bar level questions.
Can they remove the size of our eraser? If I wanted to get.
You can't bring one.
Oh, you can. That was my solution to covering up.
Still the rule, right? You can't have an external eraser. It has to be the eraser off the back of your desk.
And no, yeah, I can't remember the blank index.
Trust me, given time, trust me when I tell you this, guys, as it goes on, you will get better about being uncovered naturally. Okay? It just takes a lot of practice. You guys have been practicing doing multi-states for the last however many years of your life, multiple choice questions a completely different way. So you have to retrain your brain to go this direction. And as you retrain your brain to go this direction, it becomes just like any other skill that you practice over and over again. It becomes natural. The one I did, I mean, I literally just printed these up today before I came in here. I took them out of that book, scanned them, brought them here. I had not looked at any of these questions. You saw how I did on number 20, the very first one we did together. It was a cake. It was easy because my brain's trained to do it that way. Yours will be too, but you've got to practice the technique. And you will not be fast in the beginning. Because I think you ran out of time, didn't you?
Yes.
On the multis.
I ran out of time with the baby board.
So, because he hadn't practiced it enough to have it just be routine. I guarantee you this time he won't run out of time. You guys will eventually meet a really good friend of mine. She graduated my class. Her name is Alana. She used to do a lot of work here at the school. She actually used to work for the Dolphins. Alana, when we first started practicing for the, she was my study partner for the bar. When we first started doing multi-states, she was obnoxiously, ridiculously, horrifically slow and drove me crazy. Because I would get done with mine and I'm waiting for her. Sweet mother of God, go have 3 cigarettes, come back in, she'd finally be done. She is now just as fast as I am. She's done about 3,000 multi-states just for the bar alone, not counting anything she did previously. And she is now as fast as I used to be and as accurate as I used to be. It took her 3,000 practice questions to finally use what I've tried to teach and drill into her head all through law school. So now that she's doing it, she's extremely good. She's better at the multis now than she is at the essays, and she used to rely on her essays. So just for what it's worth, it takes time. It's a skill. Anything else, you got to practice it. Okay? Just trust me on this one. You guys need to be practicing it this way. If you don't, it's easy to not get the right answer. Other thing I want to talk to you guys about, one of my favorite subjects about multi-states, especially on the baby bar. I want you to write this down. 82 or 84? 1984?
84, okay.
I want you to go home tonight and Google the 1984 baby bar MBEs for California. One time and one time only in the history of the baby bar for the state of California, they released the multi-states. What you will find is those fact patterns in there, and sometimes the exact same flipping question will show up in the baby bar stuff. Like literally, they still use the donut one, the donut shop one a lot. They still use the bicycle shop, or the bicycle guy kid one a lot. They use the arson question a lot still too, when they hit the gas station. Okay, so by the time between now and then, you need to have it memorized.
What?
Yes, memorize. What? Somebody got a flash drive I can download. Or
What?
give me an email and I could just send it to one of you guys.
Send one.
It's the questions with the answers, the whole 9 yards.
So can I just ask, so you want us to download, you just want us to look up the 1984 California.
Print it up, and once you guys get a little bit more law under your belt, you need to be doing those at least once or twice a week.
And take those exams.
Here's one. It's only the essays. It's only the multi-states. You can go on. You can go. Okay, so let me back up. You guys can go onto the baby bar's website, and you can literally find every essay question they've ever asked, and download them and read them. Do not do that yet. You are not mentally ready for that yet, because your brain will turn to jello. Okay. Only one time though is the bar ever actually released the multi-state questions, and that was the one time they did it.
In 1984?
1984. Nobody's really sure if it wasn't an accident, but somehow or another the questions got out. The reason I say memorize them, especially for my slow readers, is you will have 4 to 6 of those on the test, and I mean verbatim. And when you see it, they don't even change the answer down below. So if you know the question and you know the answer, you can scan through to make sure they didn't switch up the A, B, C, and D, and you can get that right off the top. I know memorizing the test sounds crazy, but I promise you, after you've taken that one about 25, 30 times, it takes you about an hour and a half to get through it. And you should be at 100%.
Did you take the baby bar?
Mm-hmm.
Did you recognize some of them?
Oh yeah, I think there was like 6 or 7 in mine. They had the entire donut shop contracts question in there, which is a reasonable fact pattern and like 5 questions right after. I was like, oh yes. I zoomed through it. I was done with, okay, so you guys don't have Professor Williams anymore. She's not here because I'm taking her place. The very first midterm? It was the first midterm. You get 50 multi-states. Just 50. And you get 100 for the baby. It's 100 for the final. So I got done with the 50 multi-states in about an hour and 15 minutes. And I turned in my stuff, and Professor Williams was proctoring and walked over. She goes, "Mike, are you sure you're done?" Yeah. And they tested it, and I got 46 out of the 50. And then when we did our final, I was done, which is 100 questions. I was done in an hour and 45 minutes. You will get faster if you use this technique, because you don't have to reread questions. What you will find is you will be drawn to reread questions that you have no reason to reread, because you don't believe yourself as being capable of having the answer. So then you reread the question to make sure that it's really that you did get it right. Oh my God, I got the right answer from a law question? I'm not a lawyer. I can't know the answer to this question. I must reread it again to prove that I'm stupid. You will reread it again, come up with the same answer, and you've now wasted a minute and a half to 2 minutes. So I'm just telling you guys, the hardest part about this one is breaking old habits. The second hardest part about this is learning to develop confidence. The confidence comes with, I know what my answer is, I now look for my answer and I find it, but I read the answer right above it first and that sounded good too. Oh shit, what do I do? You trust what your answer was. Do not deviate from it. Do not second guess yourselves. You are in law school. You are studying this stuff. If you can't study this for 9 months and be prepared to take some stupid little test, and then go into it and know that you've prepared to a point to where you're capable of finding the right answer, you are already setting yourself up for failure. Half of doing this is having confidence in what you're doing. Don't fall for the, I've never heard of this legal term before, oh my God, this must be the answer. I will throw stuff at you. If you come back and tell me that you did that, I swear to you I will find something heavy, I will hurl it at you. Because when I do the Saturday stuff, I'm not contract professor, Mr. Wheeler. I'm Saturday professor for Gaylor. And I won't put up with that. You guys have got to develop the skill set that you can trust and believe in what you're capable of doing. Am I clear?
Yes.
Yes. Everybody? Okay. Second thing is practice. As you guys get, probably after your first midterm, you'll be at a point where you should be trying to do at least 50 multi-states a week, minimum. Okay? Figure out what your worst subject is. Better not be contracts. My God.
So bad.
So, once you figure out what your worst one is, there's nothing better to give yourself black letter law review than to do multi-states. Do them with a book that gives you the answers and explains why it's got the answer. Read the answer. I'll go, oh, I got it right, and not read it. You might have got it right by accident. Read it. But you've got to practice it. You have to be practicing it. You're not ready to practice it yet because you've got such a minutiae level of the law. I'm literally having to scramble to find questions to ask you guys. But it's more important, I'm not concerned whether or not you get the right answer right. I'm concerned with you guys practicing the technique and getting the technique down. Even I don't get 100%. So right answers aren't what's important. What's important is being able to do the technique and the system as you're practicing. All right? Trust me, that is way more important. Last thing I'm going to tell you about this, and I'll get you guys out of here. When you're practicing multi-states, this is going to sound absolutely ridiculous and asinine, but about as you guys get closer to it, are you guys already in study groups yet? Please tell me you guys are getting okay. This conversation never took place. Am I clear?
Yes.
Okay. If I find out it gets out that this conversation took place, y'all, we're gonna have some, that would be brilliant. Y'all need to get together, come up with a set of rule statements that you all agree to in all of your subjects, and all practice them together. As you get closer to midterms and finals, you need to be getting together and issue spotting essays. Don't necessarily write the whole essay, but issue spot the hell out of it. Go through it. These are all the things I'm going to be talking about. And practice doing that together. Because you might miss something that you caught. You might catch something that you caught, but you also came up with a different answer, and here's why. Oh, shit. Because there's not necessarily one right answer to the essays. You can wax and wane philosophically a little bit in a couple areas. that you guys should be practicing going through an essay and finding all the issues, what you would talk about. You should be practicing doing multi-states. Do them literally like we're doing. Read the question, come up with an answer, everybody's done. What did you guys get? Okay, let's go read the answer together. Here's something else you're gonna find. You said your worst subject is contracts, right? Who's doing good in contracts? I think you got a pretty good grasp on it. One, okay. As crazy as that sounds, that's not uncommon. Contracts is the hardest class to absorb, I promise you. I loved it. So I was top grading contracts, but even I struggled with different parts, okay? But guess what my role was when we would do contracts and do our review for contracts? If you didn't get it, I explained it to you. If you didn't get it, I explained it to you. Until you can explain it back to me. What's your best subject?
Probably grammar torts.
Okay. Who's struggling with torts? I did. I hated torts. I was horrible at torts. Seriously, I was not good at it. Guess what I got my highest baby bar and essay score on when I took the baby bar? Torts. Why? Because I got to the point where I had to explain it to the people in my class that were good at it. And then I got good at it. And I got faster at my definitions. So I'm telling you guys, at least for baby, if nothing else, for baby bar purposes, y'all need to be pairing up and studying. At least with one other person. Don't stick yourself in a room by yourself and think that you're going to be able to study and prepare for this test on your own. Doesn't work that way. And it'll be easier for you guys in the long run if you all come up with the same rule statements. Okay? Because then you guys are all on the same page.
That's what Mr. Dolan's doing for criminal. He usually does inside of this.
I'm still trying to figure out a way to do this for you guys for contracts. To give you guys your rule statements, your straight up rules. It's an internal debate taking place. Okay.
Speed process.
Yeah. Please. You know, it's a little frustrating when you won't give us school. That's why, like, the other class, I was like, hey, you just like, what do you want to see for?
So have you guys met Nicole Ebar yet?
Yes, last week.
You guys meet Nicole? She was here last week?
Yeah, she was here last week.
Oh, yeah.
Was she the lady that worked for the Dodgers?
Not last week, 2 weeks ago.
She's the one that works for Burton Associates doing trust work.
Oh, she was
With the
the
blonde
one.
hair.
Yeah, she had blonde hair.
Did she give you guys her email address by chance?
Yeah.
Did she?
No,
no.
I don't think she did.
She didn't.
She had a good
Why
rule
is that?
statement.
Because if you could get in touch with Nicole, there's a really good chance that you could ask her for her definitions for contracts. She'd probably give it to you. Just saying.
And someone's applied in her email.
What can we give her?
Coming from a law firm.
So just saying, she could probably be enabled to keep confident up for you guys. Here's what I will tell you, and this is again Saturday. This is Mike on Saturday talking to you. This is not your professor in contract. Nobody's going to care what your grade is in any class, as long as you pass your test. As long as you pass, nobody cares. What they do care about is that you pass the baby mark. Guys kind of getting my gist here?
Yes.
Okay. Survive law school, pass the damn test. So practice what you need to do to pass the test. Okay?
Sure.
Now, your professor says you need to make sure you do good in your class. Okay? But the guy that comes in and helps you guys on Saturday says, screw that shit. I had horrible grades my second year because I was pressing the baby bar. I had to literally relearn my second year subjects for the bar exam because I couldn't tell you shit. I crammed every night beforehand and that's all I got for it. Because the rest of the time, all my Saturday writings, I was doing stuff for the baby bar. So, just saying, kind of get yourselves in that mindset. Because trust me, you can ask the two of them. You do not want to be going into your second year still having to learn and prepare for the baby bar. It sucks.
Second year is materially a lot harder.
Yep. Oh, it's by far. By far.
Content. Hey, I could read a couple of them, so like guessed as much as I can, but I'm sure I've got thanks on a couple of them, so if you want to just give it to me.
So, any other questions about multis? Igor.
She said she was gonna come and speak regarding the baby wire.
Kelly will have it.
What's your
Ask the special contracts, please
Daniel?
send out the rule statement.
Yeah.
Giving you guys, are you thinking about the actual rules that they're talking? I'm not saying that I use the tools.
Law.
But
We don't have access to her at this point in time, right?
you can probably get in touch with her if you try to.
From who?
Google it, because
I read.
She comes in sometimes and teaches the 4L how to see her. Yep.
I would like to say thank you all for emailing the slides out. Because last they came away, it was hard.
Okay, what's her name? No, her name.
That's all on the code professional. I don't do that.
Ebar.
Yeah, but I think you could maybe persuade.
You should be getting them in this time frame from now on. Okay, so one from us earlier now to get it uploaded.
Here's what
Charles W. Ross at gmail.com.
The first 2 weeks.
Okay.
That's like all the rules.
That was helpful.
Oh, yeah.
Charles W.
Charles W.
I'm sorry. Rod Rodriguez.
But we still, there's still more that we're learning.
Yeah, exactly.
Like I feel like I've been pregnant forever, so I stress. Oh, really?
See you later, man. Have a good day.
Yeah.
Okay.
Have a good week.
Yeah.
I said, I have to add it, or to get it.
Maybe it's time for us to FaceTime when we
I'll
meet.
see you every day on
Since
Tuesday.
we're so far apart, it's hard to get there.
Right, yeah, that would work.
Have you,
I write my notes.
have you got your, torch reading?
Yeah.
Already, right? You've done your contracts?
Good night. See you Thursday.
I was saving that for last week.
I'm gonna send you that again.
Thank you.
You're welcome, guys.
I don't think I'll class because if I.
You started.
How are you next?
Thank you for that.
Oh, you're welcome.
You're able to see?
Yours were the best.
Okay, good. I did it on purpose. Thank you.
What, Brian? Someone hospital, they put her in the long term. We're waiting to hear, if they're gonna have to think her in still.
Okay.
Her heart rate is only at 42 beats a minute. Got her this morning.
Oh, well.
And they did the echocardiogram yesterday. They found fluid on her lungs. So they gotta get the Lasix in there to get the fluid off the lungs. And then if the heart rate doesn't get back to at least in the 60s by the end of, because she was on medicine to lower it.
Yeah.
Beforehand, so now they've got to get that all out of her system before they can see what they're going to do next.
Okay.
So, I'll talk with you. We got a busy week coming up. Don't schedule anything for me Monday afternoon.
Awesome, thanks. Well, everybody gonna come move you back.
Just one. We've already got one of the books, but the girl was supposed to come in that one Friday and Flake was going to come in this Friday coming up and didn't put on the calendar. But got served the papers, so she's coming in Monday afternoon at 2:30. I can Marisol, give me 1 second, really quick. Like 2 minutes?
Yeah, 10 minutes.
Okay, so for you, this will make sense. You two, this will not make any sense.
No, you turn it yourself.
You got causation, breach, damages, right? Okay. It's been a long time. Really? Okay. When you're going through the multi-states on this, you have to remember who are you representing. Am I representing the plaintiff? Or representing the defendant? Okay. Whichever one I'm trying to do, I'm trying to prove or I'm trying to defend, you start at the opposite end. If I'm the defendant, the first thing I want to do is knock out duty. If I can't knock out duty, I want to knock out a breach. If I can't knock out breach, I want to knock out my causation to the actual proximate. I can't do that, I want to say that there's no damages. If I'm the plaintiff, I want to prove that I had damages. You have caused my damages. It's because you breached and you had a duty. So what'll get you in trouble is if you forget where you're at, it can affect which one you want to go look at. Okay? So you want to, again, you want to stick with your elemental defenses, but you want to make sure you're either proving up or proving down the chain. So when you're doing anytime you get a negligence multi-state, try this and see where you're at. If you're doing that, if you did good on the essay, it's not your black letter law knowledge. It's your application of the multi-state. So you need to know where you're at, and if you know where you're at and who you're representing, and you work that direction, it's easier. Okay, so remember, if I'm trying to prove that I'm the plaintiff, I want to start at damages and work my way up. If I'm defending against it, I want to try to knock off the earliest one. Okay. What you'll see is you'll get somebody that had a duty, that breached their duty, but I have no causation, and I'll also have no damages. If that's the case, this is the right answer if I'm defending.
Okay.
Because it's the first one I knocked out. So if I can prove, so think about if you're in trial.
You can go down.
Exactly.
Yeah.
So,
Okay.
so even though there was no damages, that's not working because I stopped the causation. Any damages you may have suffered are not my problem because I wasn't the cause of it.
Okay.
So if I'm here and I have no damages and I have no causation, this one's the bigger one. I want to make sure I have damages. Okay. So that's where you'll see that hang up. What'll happen, that's why this is important when you're doing negligence, but always do your fingers off to the side. And make sure you satisfy each one.
Okay. What about defamation? There was one that I was just like, what the heck am I reading?
Okay. So on defamations, what's your rule? Let me get this off here.
Defamation is a defamation that was intentionally or negligently published to a third person. The third person understood it to be a plaintiff, and the plaintiff suffered damages.
Okay. What does that mean?
So the false defamatory statement.
False. Don't ever put the word you're defining into your definition.
Okay.
But your definition of defamation, a false or defamatory statement, well, you can define it.
Okay.
It's a false statement.
Okay.
Published, which means the third person overheard it, which the third person believed to be true, and or not to be true, but believed to be about the other party, right? And there has to be damages or no?
Well, yeah, that's your reputation, right?
Always.
No. So you got to determine who we're talking about, a public figure.
You know, public figure, not a public figure, or one. But even if it's, you got per se, you got regular, right? If the statement was about what?
So if it's club as per se, then damages are presumed.
Exactly. But if it's not club, you need to have damages. If you don't have damages, you have no tort. And the only reason you get it with club is because you can presume that there's going to be damages, so you don't have to. Otherwise, you've got to prove your damages. And if it's a public figure, it has to be what?
It has to be malice.
Malicious.
Yeah.
So, and it also has to, you have to know that you're going to be screwing somebody up. It can't just be by accident. Yep. Okay, and don't ever forget that defamation technically is an intentional tort.
Technically, yeah.
So that's what you compare it with intentional fiction and emotional distress. Okay.
Because technically it's an intentional tort. I'm intending to put something out that I know is false.
And that's what I missed, the intentional fiction and emotional distress in my essay.
There you go. So you have to know that those are, you've got your intentional torts and then you've got your pseudo-intentional torts. This is a pseudo-intentional tort.
Just like the nuisance. Okay.
So just kind of keep that in your mind. But that's what you want to make sure bring me your rule statements, let me take a look at your rules. And then we'll see where you're at. Bring me your essays.
Oh, yeah.
Bring them.
Thursday?
Thursday.
Okay. Oh, you're gonna become so funny.
No, because look, you gotta remember, kid, I took this 3 times.
Yeah, thank you so much. I don't know if I would introduce myself, sorry.
So I took it took me 3 shots. There's nothing wrong with failing, and you know what? I think it helped me more. I firmly believe that having to sit for the baby bar 3 times made me better for the bar. So there's nothing wrong with not passing the first time, as long as we identify why and correct the problems. So when you take a look at your essays, I am not the essay guru or drug guru, okay? But I will look at them and see where you're at. I want to see your rule statements. I want to make sure you know your elements, because multi-states are all about the elements. It truly, truly is. If you've got your elements down pat, and you can list them off and then tick mark them off and take them out of the equation, you'll increase your scores from that. But the key is to remember that you've got to, don't shortcut the system. You've got to do the steps. If you don't do the steps, you will miss them. And you just got to trust the process. So that's the biggest part. If your multis came up that much with just 2 weeks of practice, you need to be driving into them. Okay, because you can rack up a lot of points. If you could, I mean, think about it this way. If you could have bumped up your multi-stays from, what'd you get, 62?
61.
61, if you could have gone to a 90 or a 70. 70s, that's 9 times 3.5. It's almost 30 points you could add to your overall score. You think about it. 9 of them at 3.5.
Yeah.
What was your guys' final weight on the multis? It was like 3.8 something or
3.8 something, yeah.
Yeah, okay. So take 9 times 3.8, and math doesn't lie. 3.8 times 9, 72, 27, 34, 34 points, 34.2 points.
Why isn't it an even 4 points?
Because it's weighted off. It starts at 4 and gets weighted by how you get it doing this.
Oh.
So, 34 points. Just to get 9 more right. So now you said you did 55, 55,
60, 65.
65. Okay. So you're off by 15, 30, 40, 45 points. So think about this. If we can get these up 5 points each, just 5, you're at 60, 60, 65, and 70. You're 10, 20, 25 points. You would pass it.
You can't do 2 contracts in a row.
Thank God. That's what I want to get.
But see, that's better though.
That's so much better for us.
2 contracts, once you get good at contracts, it's better for you. Because most people can't get through them.
I just don't know. I get lost when I'm writing the essay. I'm just like, what do I do? I don't know.
Okay, so let's keep this in mind. Contracts and essays are linear.
Yes.
Okay, you're going to talk about the same things in the same order every time. So stop being so scared of them and start kind of enjoying it. You're the easiest essay to write one for except for the easiest essay to write. I mean, think about it. I'm always going to have a foot in the wall, right? And I'm always going to have it as UCC. I'm going to have merch goods and merchants, right? Even if I don't see it. It's UCC. If it's not UCC, I get to go straight to offer. Right? Acceptance. Consideration. Defenses to performance. Gratitude to frauds. Right? And I have my performance issues. Conditions. All that wonderful stuff, right? And after I get through that, what do I have next? Breach. And then I have what? 2 types of breach, right?
Yeah, material or immaterial.
Exactly. When I get through my breach, then what do? No, defense is breach.
Oh,
That's it.
okay.
Damages. And remedies.
Over.
you have to end up with
It's the same message every time. All I change is who the people are, and what the goods or services are, and what the dollar amounts are. I mean, every time. That's what you're going to talk about. It doesn't change.
We got two, common.
Okay, I got the outline. I sent it to everyone.
Good, I didn't tell you to do that.
No.
It's always the same. Then you might throw in, there might be something besides statute of frauds. You might have a mailbox rule. Remember, you got two. You got the for offer and you got a mailbox rule for acceptance. You might have some mailbox rule going on here. You might have a counter offer. You might have a firm offer, but they're always in the same place. You might have a third party vendor. Which comes up in here to
After.
it's in performance or after performance. That's how I always put it. Okay. What's so hard? It's the same message every time. Take your approach. If you got your approach, you just retype your approach over and over and over again. Till you got it memorized. The hardest part about contracts is getting to the end and doing it in enough time. That's the hardest part. Once you get to where you can do that, contracts are easy. It's actually the easiest essay because you will do the same thing every single time.
Oh, get me, come on.
Wow. Big see my appreciation.
What's that? So, again, bring me the stuff on Thursday. You're welcome. Just like I said, I think that I'm not, now that I'm teaching here, I'm not doing forever tutor anymore, but I will help you out as much as I can on my end. So that means bring your stuff Thursday. I will take a look at it. I'll go back to you next week for the following, see what you did. You're doing your multi-states and negligence, be really watching for that. I guarantee that's not something you have to criminal law should have.